18 and 19, Lordship. If the matter become infractious, Lord.
My lord, in item 18, I am the petitioner. The tenure of the fishery has come to an end, my lord. So, your lordship,
Item 18 and 19.
Yes, Lord.
You are there
Yes.
as a petitioner.
No, as a respondent.
I'm,
Let the
I'm
petitioner
appearing,
say.
I'm appearing for the petitioner in item number 18, my lord. The tenure of the fishery, which we have assailed, was for a period of 1 year, my lord. And the tenure has come to an end, my lord. So I have basically asked my learned friend that whether the tenure was extended. It wasn't extended.
Hmm?
I have asked my learned friend whether the tenure was extended, my lord, because the tenure we have challenged against this settlement made to the private respondent has come to an end. My lord. So my cause has basically come to an end. So your lordship can close the.
We do one thing, not to take it in the mention.
Yes, my lord.
We will take it when the matter is solved.
In fact, I told my learned
Because I have to mention that aspect.
Of course.
It won't be proper.
No, I'm highly obliged.
Of course, 19.
Same.
I'm deeply obliged.
May it please, Your Lordship.
Yes.
Lordship, item number 36, Your Lordship might not take up the matter.
Okay. Not before me.
I'm okay.
May it please, my lords. My lord, in item number 8, we have sent the affidavit for vetting. I pray for 1 week's time, my lord, to file the affidavit.
We'll take it up when the matter comes.
I'm obliged.
Item number 54.
Item number 1.
My lord, in this case, the petitioner expired.
So,
I think, my lord, the case survives because the case was, my lord, on the basis of certain affair. Affair was lost by alleging that 2 girls were kidnapped. And lordship kindly said the last order court expressed the anxiety as to why the invasion could not have been completed. But even then, my lord, since my authority ceased to exist because of expiry of the petitioner, so my lord, I have no location to make any submission. So lordship may, considering the fact, my lord, if lordship desires to proceed further, he may take alternative measures. And in the meantime, my lord, one Mr. Shina, P. Shina, he appeared on behalf of, my lord, the wife of the petitioner. He made an application for imprisonment.
now what has happened, Mr. Pukashka?
My lord,
What are you asking out here?
I am today, my lord, at the moment, I have no authority to speak out anything because my petitioner are expert.
Understood. But whatever may be, this is a matter pertaining to what?
Pertaining to, my lord, one affair was lost. My lord, alleging, my lord, kidnapping of 2 girls on their way to residence from their school, boarding school. Then affair was, my lord, not acted upon. Number of occasions, my lord, they approached, even to the extent of, my lord, approaching the secretary by issuing a warrant of arrest, warrant of search. That was not even executed. Then I had to file a writ petition. And matter dragged from since 2012. And they appeared, and a private respondent appeared, informant appeared, my lord, all are before the court, and court issued a direction to execute the order, my lord. They did not execute the order. Ultimately, court expressed the view that since the matter was not taken care of by the state machinery, therefore, why should not court, my lord, direct the CBI to take up the investigation? That reflects in the last order, my lord, I think. So this is the position. So it is for the court to proceed further. Some affidavit was also filed by the government as well as the, my lord, Parambade Police Station, Manipur. Our basic prayer was that, my lord, expedite the investigation to recover the minor girls from the long-term confinement of the accused person. That was the initial prayer. And to apprehend the accused person. And in the, my lord, during the pendency of the investigation, SDGM Kachar, Silchar also issued, my lord, warrant in terms of section 97 CRPC.
You are paying for?
I am for the wife, my lord, the repetitioner, my lord. Since my husband died, so since the matter is going on, so the matter will be dropped, my lord.
Why?
Because matter will be dropped because my husband has already died, my lord.
So you don't want your girls?
No, my lord, because since the matter is coming up in the name of my husband, so my lord. So we are not there or we are not involved in any way. We do not know anything about the things, my lord. So we think since the person is died, so the matter may be dropped.
I can't take it because on the basis of that, you have
No,
to be.
I have filed the implement petition, my lord, but my name has not been shown today, my lord. So
Anyway,
I'm without brief now, my lord.
anyways, yes, Mr.
Yes, Lord.
Sharma, what is it? Why the investigation has not yet been completed?
Lordship,
There
may,
is a direction to the superintendent of police also. What
yes,
has he
Lordship,
done?
that
He was
letter,
supposed
Lordship,
to submit the report. Why he has not submitted the report?
the IGP Lordship communicated that letter to the SP. It was sent to us, Lordship, but
SP of what?
may I,
SP of which we
Kachar.
asked him to be present.
Thereafter, Lordship, what happened, Lordship, may I pray, Lordship, I am taking up, as because this letter was sent to the personal department, may I pray, Lordship, let this matter be taken up at 2 or
We'll take it up again at 2, but in the meantime, you get your thing.
yes, Lordship,
There are 2 directions passed by this court.
yes,
As regard the superintendent of police, asking him to submit a report why there has been so delay in the investigation.
in paragraph number 6 of that order, Lordship. The
I've
court
seen it.
expects the said authorities to have interstate communication amongst each other so that an appropriate report is sent to by the superintendent.
Not once, twice there is an order. You
Lordship.
see, not that.
Lordship.
Kindly see the order of
Yes,
3-1, see the order of 3-6-2023. Then the order at 15-6-2023. Then again on 19-7-2023. Why?
Lordship.
Why nothing has happened? Why does he has not submitted the report as directed?
I will try to bring it today itself, or tomorrow is 15th.
I'm not concerned.
Lordship,
I
I will
think-
try. I will try my level best, Lordship.
I think if he is the superintendent of police Kachar, what is his name?
I do not know, Lordship.
Get hold of him and ask him. You want it, otherwise let him be present. We'll take it up at 2.
Lordship.
Get the instructions.
Now, what would be my rule?
Huh?
What would be my rule?
Your role is to assist the court.
Assist the court. As an amicus curiae.
No, this matter is of when there are this court have already in public interest taken up the matter, and there are certain directions been passed
As a-
whereby the superintendent of police has been directed to submit a report,
Mal.
the non-compliance of which gives the jurisdiction of this court.
Lordship.
Whether the petitioner is there or petitioner is not there, or the legal representatives of the petitioner is not interested, is not the question now.
Fine.
A
Apart
crime has
from
been
that, Lordship,
committed.
it's
And
a
the crime
criminal
has to
case
be
against
brought
the
to a
state,
logical
Lordship.
conclusion.
My lord, my lord.
It can't
State is
take
involved here,
11 years for that.
Lordship. It's a criminal case, Lordship. State is involved where his presence is not required, Lordship. Why the investigation is not complete? I will try to bring it, Lordship, by 2 weeks.
Number two.
Please, your lordship. My lord, this petition has been preferred against the judgment and order of the learned Board of Revenue, my lord. The appeal was heard at the relevant time, my lord. The counsel concerned for the appellant before the board failed to appear, and the matter was taken up by the board, and on merit it was decided. The board can, my lord, because Order 41 Rule 17 is not applicable. Board has the power to hear, to take up hearing in absence of the appellant's counsel also. So I am not on that, because Revenue Board took up the matter as per the provision of law. I am agreed, my lord, because on the last occasion, your lordship was pleased to make a query whether a registered sale deed involving the disputed land is there. But admittedly, there is no registered sale deed, my lord. Transaction was made for 1 bigha, 2 kothas, 18 lesas for a consideration of rupees 24,000. And as per registration act, registration is compulsory, my lord. But my humble submission before lordship, that I have the information that the land is within tribal belt, my lord. And when the land is within tribal belt,
Are you a tribal?
my lord,
Are you a tribal?
no, I am a scheduled caste. I am a scheduled caste.
Scheduled caste has no business out there.
No. Why I am submitting this? Because the land was transferred from a general caste. It was a Mohammedan, and that land was transferred to another Mohammedan person, and from that second person, my Bhendi, he was also Muslim. I purchased it in the year 19.
But your deed of sale is not registered.
No, my lord, deed of sale was not there on affidavit and on a written agreement. No, my lord, that's why I am submitting. I am submitting this because under,
Yes, Mr. Ka.
under,
There's only an affidavit, no deed at all.
Huh?
I have admitted.
In your case, there is a deed.
No, my father was the original, the Pattadar, prior to 1948. That is our contention, man. He expired in the year 1988-89, when we were minors. And it is an admitted case that even our mother expired within 1 or 2 years thereafter. So at the time when both the parents expired, we were minors. Much later, my lord, when we came to know, because our father actually had land, as your lordship knows, in these places, vacant land, so many places. We found that our father was a Pattadar in having so many lands. But obviously, because taking advantage of our minority, my lord, most of those lands were encroached by other peoples. And they, my lord, by whatever means possible, in this case, lordship has seen, my lord.
No,
Which is an
then what
affidavit.
happened?
Then, my lord, when we came to know, then we applied for the records, and we prayed for the cancellation of the mutation of his name. Because what has happened in this case, my father's name is Fazar Ali. Now, from Fazar Ali, my lord, the land was directly mutated in the name of Hari Gopal Biswas. That is these petitioners, my lord. But the person in whose name, who purported to transfer the land, Taibuddin Sheikh, that the board has found that there was never any transfer in his name, because there is no mutation.
So
no
that
transfer.
Saifuddin Sheikh transferred it to the
Yes,
petitioner.
by way of and that too by way of an affidavit. And in fact, my lord, regarding
And how did Saifuddin Sheikh get it?
no, that is nobody, because there is
Oh,
no.
he sold it by himself,
He sold it by himself.
by way of an affidavit.
Yes, and the land was directly mutated.
And on the basis of an affidavit, it has been mutated.
Yes, it was mutated, and that is the mutation that we prayed for cancellation.
And it was cancelled.
Yes, it was cancelled, man. It
And
was
then-
cancelled. That order, my lord, was
Cancelled by whom? The
cancelled by the order of the deputy commissioner.
Then they preferred an appeal.
They preferred in appeal.
That appeal was dismissed. And now you are before this
Yes, my
court.
dear.
My lord, my humble submission before lordship, that chapter 10, rule 160, my lord, that regarding transfer of area within tribal belt. Now,
But madam,
yes,
whether that would apply in respect to inheritance.
No, my lord. Actually, Rule 53 for registration, it prescribes that when possession is there, the petitioners before lordship, their names got mutated on the strength of inheritance. Because
On the strength of?
on the strength of inheritance. On the strength of inheritance, because our father's name were earlier mutated in place of Hazar Ali, the registrar in interest of the respondents. My lord, the revenue board was absolutely wrong in coming to a finding that unless and until the name of our vendor is mutated, how the mutation can be granted directly? There is no such provision. The learned GC also, ADC also committed the same wrong. That for mutation, every vendor or vendee's name is to be mutated. There is no such rule, my lord. It is not necessary because when the title is there,
No. Kindly tell me what is your title? How did you get your title?
No, title by purchase, by gift, by
How?
Yes. Because on affidavit it was purchased.
Can you purchase it by way of an
No. Why I am submitting? Why it was not registered? I am submitting, my lord. Lordship, maybe please excuse me. I'm not very well.
Title suit pending between the same parties. Title suit pending between the same parties. I have filed the title suit 2016.
Chapter 10, my lord.
Huh?
Chapter 10.
No, that's chapter 10.
Yes,
Chapter 10 is in respect to tribal nets.
tribal bill. Now,
Okay, very well understood. But that chapter 10 say
Hmm.
that the immovable property can be transferred by way of an affidavit.
no, it can, but why? Because registration, why I'm submitting this, why registration was not done? Here, in this case, my lord, Rule 3, my lord, it was asserted by the Act of 1964, provided that nothing contained in this chapter or in the rules made thereunder shall affect any transfer. Oh, no. No, this 3, my lord. From and after the commencement of the Assam Land and Revenue Regulation Amendment Act 1964, no document evidencing any transaction for acquisition or possession of any land by way of transfer, exchange, lease agreement, or settlement shall be registered under the Indian Registration Act. If it appears to the registering authority that the transaction has been effected in contravention of the provisions of subsection 2. Now, my lord, that is why, my lord, registration was not done. But registration was not done. Register could not be approached, my lord. Register could not be approached. So,
Madam, just tell me one thing. No, I understand.
and one more.
No, madam, one thing, just one. Just for my clarity. You know, now we have section 21A, where you need a objection, no objection. Now, unless the no objection is not granted, the registration officer shall not transfer a register. Is it? Now, can you say that you have a right on the property on the basis that the no objection was not given by the deputy commissioner?
No, my lord. But in that case, my lord, when possession is admitted, I was in long possession, my lord, since the date of purchase, then on my date, my heirs also stepped into my shoes. Now, there is a decision of this honorable court, my lord. This honorable 1991 JLJ. Our court has laid down what the revenue authority can do. The revenue authorities do not have power to decide questions of title is obvious from a reading of section 41 of the Act. When title is relevant, the revenue authorities are to refer the parties to civil court. That is the scope of section 41 of the Act. Nevertheless, question of title prevailed in the orders of the authorities. The Assistant Settlement Officer, and the Board of Revenue have power to consider possession, and possession alone can be determined. When the issue as to title arises, the authorities have no jurisdiction to decide such an issue, and the parties have to be referred to civil court. So in this case, my lord, when possession is admitted, and when that was set aside, the order was set aside by the granting mutation of the circle officer was set aside by the learned DC, holding that mutation was granted in contravention of the provisions that Toyobuden's name was not mutated. That was the ground. Toyobuden's name was not mutated. Directly, the name of the petitioner in interest of the present petitioners were mutated in the name of Hazar Ali. So is it not wrong, my lord, that for mutation, there is no such procedure that every vendor's name is to be mutated? Learned ADC as well as the board at page 54, board has held that after hearing both the parties, Lakhimpur ADC allowed the said appeal entirely on the ground that the impugned mutation was effected directly in the name of late Haran Biswas in place of Hazar Ali, even though the claim of the legal heir of late Haran Biswas is that he had purchased the land through an affidavit from Muhammad Taibuddin Ali Sheikhs, who had originally purchased from the lands from late Hazar Ali. And here also at page 55,
Mr.
board has said-
Mr. Ganguly, you are appearing for?
But I have to for 3 to 10 minutes.
You are the legal representatives of Fazal Ali.
Puzzle, yes.
Enough,
My lord,
madam,
is it not,
enough.
my lord, is
Enough.
it not
Lot-
wrong,
lot
my
of
lord, to
Time has
I know,
gone
my
now, whatever may be. I've heard you, enough.
no, they have preferred a suit, my lord. They-
Very well, suit is
Yes.
there, but first and foremost, no, madam, kindly listen. Section 50 of the regulation 50 of the Assam Land and Revenue Regulation categorically mentions that you have to have two things,
Yes.
not only one,
Yes.
possession
And title,
and title
yes,
for mutation.
yes.
You don't have the title.
I,
You
yes,
don't have the, you could not even prima facie show that there is a title.
but
There is a
now,
clear categorical violation of section 54. There is a clear categorical violation of section 17. And as such, you have no title. That is very clear, which is apparent from the Boards of Revenue order. Now he has filed a suit. Now the suit will be there, but this order of the Board of Revenue has to be upheld. However, I say that will be upholding shall not affect your rights if your rights in respect to the suit. That's the nothing doing. The instant repudiation has been filed challenging the order dated judgment and order dated 30/5/2017 passed by the Learned Board of Revenue in RA (L) number 2/2015, thereby affirming the order dated 4/8/2014 passed by the Learned ADC in RA 5/2013. A perusal of the materials on report show that the father of the respondent numbers 3 to 10, the predecessor in interest of the respondent numbers 3 to 10 was the owner of a plot of land measuring
1 bigger, 2 kathas, 18 lessons.
Where do I get the land? 1 bigha, 2 katha, 18 lechas, covered by dag number 266 of PP of periodic patta number 5 under Moza Naobosia number 2 Urang Bosti map in the district of Lakhimpur, Assam. The said land, for the sake of convenience, is hereinafter referred to as the land in question. Pustak. The predecessor in interest of the respondent numbers 3 to 10 expired in the year on 4/10/1989. Pustak. The respondent number 3 to 10 at that relevant point of time were minors. Pustak. Upon attaining the majority and making inquiry, they could find that the land had been mutated. The land in question had been mutated in the name of
Haren Biswas name.
one Haren Biswas, the predecessor in interest of the petitioner. Under such circumstances, an application was filed, an appeal was filed before the learned deputy commissioner, Lakhimpur, not Lakhimpur, bracket RKG branch, which was registered and numbered as Revenue Appeal number 5/2013. The learned deputy commissioner, Lakhimpur, by an order dated 4/8/2014, taking into account that there was that Haren Biswas, that the said Haren Biswas, bracket since deceased, had no right over the land in question, had set aside the mutation and directed the circle officer Novosia Revenue Circle to correct the land records in the original, in the name of the original patadar, that is the predecessor in interest of the respondent number 3 to 10, by restoring his name. The petitioner herein, being aggrieved, had preferred an appeal before the learned Assam Board of Revenue, which was registered and numbered as RA bracket L number 2/2015. The learned Assam Board of Revenue, by the judgment and order dated 30/5/2017, had dismissed the said appeal. In the said judgment and order, in the said judgment dated 30/5/2017, the learned Assam Board of Revenue have observed that a record revealed that the appellant's, that the petitioner's father, late Haren Biswas, had mutated his name in place of late Fazar Ali, from whom Haren Biswas never purchased the disputed land, the land in question. The learned Board of Revenue have also taken into consideration that the petitioner's father purchased the land in question from one Taibuddin Ali Sheikh, and on the basis of that had obtained the mutation. It was also observed that the learned, that late Haren Biswas, that is the father of the petitioner, had purchased the land from the said Taibuddin Ali Sheikh on the basis of an affidavit dated 16/8/1998, that too for a consideration of rupees 20,000.
24,000, right?
It was duly taken note of that as the property in question is of a value more than one, as the property land in question being an immovable property of a value more than rupees 100, the same can only be done so by way of a registered deed of sale. It is under such circumstances it was observed that late Horen Biswas did not acquire any title on the basis of the deed of sale, on the basis of the affidavit dated 16/8/1998, executed by one Tahibuddin Ali Sheikh, and as such found no infirmity with the order dated 4/8/2014, passed in Revenue Appeal number 5/2013 by the Office of by the Deputy Commissioner Lakhimpur, by the Additional Deputy Commissioner Revenue Lakhimpur, not Lakhimpur. On the basis thereof, the appeal was dismissed. It is under such circumstances that the petitioner herein has approached this court, assailing the orders passed by both the Learned Board of Revenue as well as by the Additional Deputy Commissioner Revenue Lakhimpur. Ms. B. Chaudhary, the Learned Counsel, appearing on behalf of the petitioner, duly admits to the fact that there was no deed of registration on the basis of which the father of the petitioner had acquired right over the land. She, however, submits that in view of the chapter 10, submits that as the land in question is a land falling within chapter 10 of the Assam Land and Revenue Regulation 1886, there is no registration is impermissible. The sub-register, the registering authority cannot register the land in favor of a non-tribal, and it is under such circumstances the affidavit was executed by Tahibuddin Ali Sheikh. She further submitted that as the petitioner as well as his father were in possession of the suit land, of the land in question, the mutation ought not to have been cancelled. These are the two submissions. On the other hand, Mr. A. Ganguly, appearing on behalf of the respondent number 3 to 10, had submitted that taking into account section 17(1) of the Registration Act 1908, read with section 54 of the Transfer of Property Act 1882, there can be no right, that no legal right can stand transferred in respect of an immovable property of a value of more than 100 rupees without a registered instrument. He further submitted it is therefore the submission of the Learned Counsel that on the basis of an affidavit filed by one Tahibuddin Ali Sheikh on 16/8/1998, the mutation could not have been granted, taking into account that no right to devolve upon the father of the petitioner on the basis of the said affidavit. The Learned Counsel further submits that there is no basis, there is nothing on record also to show how Tahibuddin Ali Sheikh acquired title over the land. Without a deed of sale being executed by the predecessor in interest of the respondent number 3 to 10. He therefore submitted that the learned additional deputy commissioner, revenue, Lakhimpur, as well as the learned board of revenue, Assam board of revenue, were justified in cancelling the mutation made in favor of the father of the petitioner. Upon hearing the learned counsels for the parties and also perusing the materials on record, this court, it appears nothing would be shown as on under what shown under upon hearing the learned counsel for the parties and perusal of the materials on record, it transpires nothing could be shown that any title had default upon the respondent number on the father of the petitioner. On the basis of a document recognized by law. This court also taking into account the provisions of section 54 of the Transfer of Property Act 1882, as well as the provisions of section 17(1) of the Registration Act 1908, which mandates that for creation of any right over an immovable property of a value of more than 100 rupees, the same has to be effected by way of a registered instrument. As there is no registered instrument in favor of the father of the petitioner, or even in favor of the petitioner, this court finds no reasons to interfere with the orders being passed by the learned additional deputy commissioner, revenue, Lakhimpur, as well as by the learned Assam board of revenue. And accordingly, the instant repetition being devoid of any merits stands dismissed. Ms. B. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that a suit has been filed by the respondent number 3 to 10.
No, only 3 to 5.
3 to 5. Being title suit number?
Title suit number 10 of 2016.
10/2016.
It's pending before the.
Which is pending before the court of?
Learned Munsif at not looking for.
Learned, nowadays we don't have Munsif, no? Before the court of the civil judge? Junior division, huh?
Junior division.
Junior division number 1 at Lakhimpur. She submits that the above observations should not affect the petitioner's rights in respect to the said suit. Taking into account the above, taking into account that the said suit so filed as submitted by Mr. A. Ganguly is a suit pertaining to right, title, and interest, and the present proceedings pertains to mutation. This court observed that the above observations so made shall not affect the petitioner in the said suit.
The amount is not 20,000 or 24. Amount is 24,000, my lord, not 20.
Okay, 24. Very good.
At number 3,
And how about the cost?
My lord.
Cost?
No, lords, it will not be, because it will belong to a court category, no cost.
Chalo. Next.
No submission could be made before the learned court by that I have already submitted.
You have a very poor case.
The
Yeah.
concerned counsel remain absent, my lord.
The trial court shall decide the said suit independently
confining itself only to the point of
independently
mutation.
without being influenced by the observations made here in the public. Yes, who is there? Item number? Three, Nepal. Three. Yes. Tell me. What is your case?
Lordship, my senior is in Lakes in.
Who is your senior?
SCCL.
What is this matter about?
Lordship, the matter is about a show cause notice which was issued in 2019 under the Finance Act after the introduction of the GST Act. So, in fact, the first line of the show cause notice starts saying that the proceedings of the inquiry started after, before the introduction of the GST Act, which is wrong. GST was introduced on 1st of July 2017, Lordship. And the notice for audit was issued to me in August 2017, Lordship. And it is to be noted, Lordship, there was an audit which was going on during this period for which the show cause notice was issued. And it was concluded only in February 2017, Lordship. So there was no reason for the authority to issue me a notice after introduction of GST for audit when there was already an audit in process when this particular period was there.
Where is the show cause notice?
Lordship. It's at page 29, Lordship.
Was conducted before the appointed day of the central goods of so and so.
Lordship, if you see page number 43, that is Annexure P1, the intimation for the audit was sent to me on 17th of August 2017, after introduction of GST. So the first line itself is stating a different fact.
Oh, for that, we only need to, can audit, is it only the audit which makes the year?
Lordship, what
There
happens?
might be other things also.
Lordship, what happens that a show
Let
cause
we have to see what is section 174 to E.
one second.
On your central exercise.
It's there on page number 11, Lordship.
Central exercise.
There it's there in my petition, Lordship.
Fantastic.
Page 11, Lordship,
Page 11.
running into page 12.
Yes. What is this? Is the saving?
This is a saving clause, Lordship.
We are concerned with 174.
174 2E.
174. This is 170 or 174.
2E, Lordship.
2 is where?
Lordship is on, it's on page number 12, provided that any tax exemption granted as an incentive. It's 8th line, Lordship.
Okay. The repeal of the said acts and the amendment of the Finance Act. And it have to you can see this. To the extent mentioned in subsection 1 or section 173 shall not affect any investigation, inquiry, verification, scrutiny and audit, assessment proceedings, adjudication or any other legal proceedings or recovery of area or remedy in respect of any such duty. And only such things. Yes. So here it not only says about audit, it says affect any investigation, inquiry, verification. Verification has two parts, which can be seen, including scrutiny and audit.
Scrutiny and audit.
So under such a, if there is an investigation, what do they say out here? The present inquiry was conducted before the appointed date of so and so have been omitted. However, in view of spells out so and so shall not affect any investigation so and so, so and so, so and so. Assessment in so and so. Whereas it appears so and so, a private company having its registration office at so and so, demand supply of demand have not paid the tax during so and so amounting to rupees 20 by way of violating the provisions stipulated in the. Whereas during the course of audit undertaken, Okay, now you are on 2, paragraph 2.
Lordship.
So this was observed only during audit.
During audit, Lordship. That was conducted after introduction of GST.
Whereas during the course of audit undertaken by the officers of so and so, it has been observed that the said notice had either short paid or not paid tax against so and so. Further, the said notice had not paid interest against delayed payment of so and also not paid the so and so. On scrutiny of the documents in the security enhancement for the period from influencer to market, opinion and proposal. Yes, now, so this is your main ground.
Lordship, this is my main ground is Lordship, because the audit was started after introduction of GST. And there was a previous audit also, which was concluded only in February 2017, Lordship. So an audit is not a compulsory exercise under the finance sector for the service tax purposes. Service tax was a self-assessment regime. Once I file my return, Lordship, and if the period of limitation gets over, then my assessment is closed. It is unlike the income tax or the sales tax law. Now, when I filed my returns in 2017, Lordship, for the previous periods, that was during the service tax regime, on the basis of my self-assessment, and an audit which was already concluded in 2017 February could not find any difficulties in those returns, Lordship. So my assessment for this particular period gets over. Now, there is only one section, that is section 73 of the Finance Act, which permits the department to recover the taxes from me for a period of 18 months from the due date. So this notice is for 2015 to 2017, which was issued in 2019, this show cause notice. So effectively, the due date would somewhere end in 2017 after introduction of GST Lordship. Now, there has to be some cause for the department to show when there was already an audit which has already been conducted prior to introduction of GST, to show that I have evaded tax with suppression of facts with a malified intention, and then they can breach into, then they can lead into the extended period of limitation, which is of 5 years. My argument is, Lordship, when there was an audit which was already going on during this period for which show cause notice has been issued, and it got concluded in February 2017. Then a subsequent notice in August 2017, after introduction of GST, which creates a liability on me by invoking the extended period.
No. Subsequent notice, this notice is of May 2019.
No, Lordship, this show cause notice is of May 2019. Now it creates a liability on me by invoking the extended period of limitation of 5 years, not of the normal period. So for invoking the extended period, there has to be some causes where I have suppressed the law or the facts from the department. Now my point is, when I was already audited once for the period which was already there.
No, but Mr. Counsel, this point can very well be agitated by you.
Lordship.
Before by filing your reply. That can be very well done. I'm not on that.
No.
But the question is whether it touches on the jurisdiction to issue this notice.
Lordship. Now
We are only on the question of jurisdiction.
Now my point is, Lordship, this is a particular right under section 73 which they can exercise, which they exercised in May 2019. For exercising this right, they conducted an audit under Rule 5A of the Service Tax. Now, Rule 5A does not grant them to conduct an audit. It simply says that you have an access to the premises for carrying out certain activities.
But you submitted yourself to that audit by submitting your papers, because you say that this on the basis of the audit, this has come to an end. Here you say, whereas during the course of audit undertaken by the officers of so and so. Now you say that the audit was issued and the notice was issued after 2017, 1st of July 2017. So you have submitted yourself to that audit.
Lordship, now the question is, if I have submitted myself to an audit which was It was only an exercise, Lordship. My point is, it was only an exercise to investigate into my things, into my books. Now, my argument is, Lordship, this audit, I'm not challenging this audit. What I am challenging is that any right to recover the text has to be saved by the section 174, Lordship. Now, my point is, Lordship, when the audit was conducted.
So your basic case is, you see, 174 did not save these aspects. Because there was nothing prior to that.
Lordship,
That is your submission.
Lordship.
That is a very well, a good submission for the purpose of jurisdiction. But what about the other submission? This submission doesn't hold it. You have submitted yourself to the audit. Now, whether it is to be done within a period of 5 years or not, that can very well be submitted by way of a reply to the show.
Lordship, the point is that at the time of conducting an audit, there is no such provision in the law which permits them to ask for the documents prior to 18 months. Because the show prior to the period of 18 months. Because the show cause notice at max can be issued for 18 months. And in this.
But you submitted your documents then.
Lordship,
Didn't you submit it for the prior?
submitted my
Then you have submitted yourself to the jurisdiction then. Why should this court look into that? Now tell me,
Lordship.
if it is not saved under 174, what happens to that action?
Which action? Audit?
You see, 174 saves certain things.
Lordship.
That if these things are done, any investigation, verification, including audits, have already been done, it is saved.
Lordship.
But if it is not done for the period earlier, then what is the consequences?
Lordship, if
Because on 1/7/2017, the GST has come.
Lordship.
Prior to that, there will be many other things. There will be many things.
Lordship.
Now, what happens to that where there is no investigation done?
Lordship.
Just for example, in 2016, something has happened. You have submitted your returns and all. What happens to those?
Lordship, that is exactly my point. In the service tax regime, because it's a case of self-assessment, if in 2016 I have filed my return within the due date, in that case, my assessment gets over. Now, on the basis of scrutiny of my returns or audit of my returns, no demand can be raised, Lordship, unless and until some action has been taken prior to introduction of GST. That is my only point, Lordship.
Are you saying that, just for example, there might be a case of, as per the earlier, we are concerned with central excise, huh? This
It's provisions are similar. Provisions are similar.
No, this is pertaining to central excise or service?
Service tax, finance tax.
Service tax. Now, service tax, you had, it has to be under the Finance Act 1994.
Okay.
Now, Finance Act 1994, just for example, there was a suo motu revision power. Recalling of the assessment or reassessment proceed. There must have been
There is no such power, Lordship. This is,
under the Finance Act 1994.
there is no such power for suo motu revision of any assessment, because in service tax regime, this is a particular aspect about the service tax regime, Lordship, that I have to file my return under the self-assessment regime under section 70. Now, if on the basis of some material which is there with the department, they can initiate a investigation proceeding under section by way of summons, Lordship. I'll just under section 14 of the Excise Act, Lordship, which gets empowered to the which gets applicable to this Finance Act by way of section 83.
Section 14 of the Central Excise Act.
Central 14
Central Excise Act. Well, but this court
There is
finds it
second
surprising that
a special
you,
audit under section.
no, if there is, if an assessment is being done of the service tax, are you saying that there is no power that if there's something wrong of that?
Power. I am saying that the power has to be exercised on the basis of some material. Now, there are two provisions under which something can be done, Lord.
No, there's no quarrel with that proposition that on the basis of material only you can exercise that power.
Sure.
if it is like in the Income Tax Act, it has to be erroneous and prejudicial to the interest of the revenue. So you can reassessment
Not-
or the sumoto revision, which
Not-
power is there. Are you saying that there is no similar powers as per out there in the Central Excise Act once the assessment is completed, unless that assessment is put to challenge by you,
Lordship,
or it attains finality on that date?
in order, Lordship.
Ah.
I'll bring it on record, Lordship. It says once I have filed my returns under a self-assessment regime, particularly with respect to service tax, then my assessment gets closed. I cannot change it even. And the department has right to investigate me under section 14 of the Excise Act by way of summons, or there is a provision for special audit under section 72A of the Finance Act.
Section 14. Audit, power to summon persons to give evidence and produce data. Any central is empowered by the central government the power to summon any person to perform the Let us see the Finance Act 1994.
I have a book, Dr.
No, because this court finds it a bit difficult. Just for example, you submit your return
Dr.
and you don't disclose many aspects.
That is a separation, Lordship. If I don't disclose in my return, then that is a separation, Lordship.
This is what they are saying in their reply, that you have not given
Lordship,
shown.
my point is that the audit was already going on when this exercise was done. When I was filing my return, they were sitting in my premise and conducting an audit. They didn't observe anything in this.
So these power under 73,
Lordship.
which is the parameter power to this reassessment or revision power.
Lordship, this is the power to recover the tax.
Yes, if it is a case they have find out
They
that
have-
there is a fraud
Lordship.
or a collusion or willful misstatement or suppression or contravention, any of the chapters out there. When so the power, yeah, the word 5 years or is even the provisions of this subsection shall have as if the word 18 months, the word 5 years have been substituted. So this is 5 years.
This is 5 years if there is suppression or willful mistake.
If these circumstances arise.
In these circumstances. Otherwise, it is 18 months.
So, being it 5 years, a person has the authority. Are you saying that if there is no investigation being carried out in the meantime, when the limitation is given for 5 years, if no investigation or anything has not been done,
Lordship,
the right accrues upon you?
My point is, Lordship, I'm not generalizing it. My point is with respect to this particular situation, Lordship. Please analyze, please just see the situation, Lordship. An audit is already going on from 2016 to 2017 February. Now the demand in this shows.
So this audit is again under the 72.
No, not 72, Lordship.
So this is a self-audit.
Now, the interesting aspect is, Lordship, that this particular audit is not under any provision of law, because under the Excise Act or under the Finance Act, there was no provision specific for a departmental audit. It was conducted by way of Rule 5A, which was challenged before the Delhi High Court in the case of mega caps, and they overruled it. But then it is pending before the Supreme Court, so I'm not going into the legality of that audit, whether it is under a section or not. But the point is, Lordship, if they were already doing an audit, now what caused them to suspect that I have suppressed some facts from them for this particular period, April 15 to March 17, and then issue a notice for audit under the Finance Act after introduction of GST, and then issue me this show cause notice after 2 years of the introduction of GST law. Because had my earlier audit
So
not been
this
conducted,
show cause notice is under what provision?
it is under provision to section 73, which you have just read, Lordship.
So this is, they are alleging for violation of this fraud, collusion, willful
Lordship.
misstatement, suppression of facts or contravention.
Lordship,
So that is what they are saying.
Lordship.
So if that is the period for that, then in view of this particular provision, the period is 5 years.
That is there. Yes.
If it is 5 years, then shouldn't that aspect be saved out there by 74, 174?
Exactly my point is, Lordship, that there has, see, this power under section 73 has to be preceded by something. They cannot themselves issue a show cause notice. They have to carry out some audit or investigation. Now, this audit or investigation has been conducted under the Finance Act after introduction of GST, and in that audit, on the basis of that audit and during that audit also, the extended period of limitation has been invoked while already an audit was conducted previously. Had my previous audit not been done, I had no case, because then they had.
Now, was that audit done under in view of under 72A?
Lordship, that both the audits were conducted by the department, not under section 72A. Neither of them was a special audit. Both of them were conducted by the department under Rule 5A
Of Central
of
Excise?
the service tax rules, Lord.
Huh?
Of the service tax rules.
This one?
It's there in the booklet, Lordship.
Service tax.
It's the next chapter, Lordship. Service tax rules. Rule 5A.
Two 2006?
Service tax rules 1994, Lordship. It's the very next chapter, Lordship. Finance Act 1994, then Service tax rules 1994.
Got it. So this is done under Rule 5A.
Rule 5A.
Access to registered premises.
Lordship.
Huh?
This is the only provision.
An officer authorized by the commissioner to this behalf shall have access to any premises registered under these rules for the purpose of carrying out any scrutiny, verification, and checks as may be necessary to safeguard the interest of revenue. So this is more like a search.
This is more like a search, Lordship. It's
Search.
only for
Shall on demand make available to the officer empowered under so-and-so or the audit party deputed to the so-and-so auditor or custodian under section 72. Now, you see, 5A2 again refers back to special audit.
Yes, Lordship. Even 5A2 doesn't talk about the normal departmental audit. And special audit has to be conducted by a chartered accountant. Because
Understood what he says, or the audit party deputed by the commissioner or controller and auditor general or a cost accountant or chartered accountant nominated under section 72A.
Lordship. It doesn't talk about the audit conducted by the department, service tax department.
Why? Or the audit party deputed by the commissioner or the comptroller and auditor general of India or cost accountant or chartered accountant nominated under section 72A of the Finance Act. The records maintained in the prepared under so-and-so, the cost of audit so-and-so for scrutiny of the officer audit party or the cost of account of so-and-so, so-and-so, so-and-so. Now, therefore, Rule 5A is a procedural provision. It couldn't be a substantive provision. The substantive provision is 72A.
72A.
Now, substantive provision under 72A says, if the principal commissioner of the Central Excise or the commissioner has reasons to believe that any person liable to pay service tax has failed to declare or determine the value of so-and-so, has failed to has operation of so-and-so, or nominated to the extent as may be, he may direct such person to get his accounts audited by a chartered accountant or a cost accountant nominated by him to the extent and for the period as may be specified by the commissioner. So here he may direct
He may direct to the SSC to get his account audited by
by
a
a,
third party.
by a chartered accountant or a cost
Cost
accountant appointed by these persons, the official.
Got it.
Shall within the period specified by the commissioner submit the report, the provision, the period, and so and so. So this audit is being done on the basis of formation of an opinion, on the basis of that the official out here has reasons to believe that these are the circumstances.
Had this been the case, this audit would have been done under 72A. My argument fails, Lordship. But this audit is not done under 72A. See, Lordship.
Which one?
My audit, Lordship. It has been.
The first one or the second one?
Both. Both have not
No.
been done by chartered accountant.
Who has done it?
The commissioner, the assistant commissioner of the department, Lordship. See,
So
page-
therefore, it is not an exercise.
Under 72A.
So as per 72A, it is only a cost accountant or a chartered accountant can do.
Lordship. And this is the precise
Liable to
reason.
pay tax shall be given or being heard in any matter gathered on the basis of payment. Shall be the meaning of tolerance. So this audit which was carried out is not under 72A.
Lordship, if you see page number 43,
Where is your senior?
Lordship, and
Is he still on legs?
yes, Lordship.
Oh, it doesn't pain? Yes, tell me.
Lordship, page number 43, this is the intimation letter for audit, which is signed
This
by
is being given by the assistant commissioner.
assistant commissioner, Lordship, and the previous audit also,
Unit
Lordship.
is scheduled to be audited by the Central Excise and Service Tax Authority. In connection, you are requested to submit the following reports for the purpose of so and.
And the Lordship, previous audit also,
So this is not a special audit.
not a special audit. And the previous audit, page 54, Lordship,
Page,
page 54, annexure P4. Interestingly, both the audit letters have been issued by the same assistant commissioner, Lordship. This is also by the same assistant commissioner on 18/3/2016.
no, but these are not under 72A.
No,
Because he has to have,
he has to
So,
mark it to,
no, and no,
allot it to. a
no,
chartered-
not only that. He has to say that he has reasons to believe that these things have happened and as such,
Yes, Lordship.
which is normally to be done in respect of any other thing, all other income tax act and everywhere. When there's a reasons to believe, he has to mention basically that he has reasons to believe that these has happened, or you can go for a search. So these can't be taken to be under 72A.
72A, Lordship, and particularly, this is the same assistant commissioner who is conducting both the audits. So how can there be a separation, Lordship? How can there be reasons to believe that I have evaded tax basis suppression? Basis some willful misstatement when you are, your
But Mr.
Party-
Counsel, are you asking this court how and when?
Lordship, I'm not asking you, Lordship.
Ah.
My apologies, Lordship, it is not that case.
How
I'm
do you
asking the
expect court?
other side,
How
Lordship.
and when? It is for the authorities to decide.
Lordship.
But
my
where is the
apologies, I take
jurisdictional
that
issue
first,
then?
Lordship.
Where's the jurisdictional issue?
The jurisdictional issue is, Lordship.
Where is the jurisdictional issue?
Lordship, the jurisdictional issue is that because there was already an audit which was conducted prior to introduction of GST. So
You may say,
are there,
that by way of the 2017 audit, he could not have gone for exercise of power under 73.
Lordship,
That may be a jurisdictional issue.
that is-
That may be a jurisdictional authority. But 73 does not say about anything about an audit also. It says what is the requirement of 73? where any service tax had not been levied, paid, or so and so, so and so, so and so for the relevant period of time or so and so, why he should not, or so and so to or person to whom such remand has been erroneously, requiring him to show cause as to why he had not. Now, this is a formation of an opinion he had
Yes, Lord.
that I have, as per me, that this is not there. And as such, he has asked you to show cause. This is the show cause of the.
Lordship. Now,
And then what is wrong with it?
Lordship, now this opinion has been formed on the basis of an audit, which is done under the finance. Act.
Not done under the Finance Act. It couldn't have been because the Finance Act only says about 72A.
Lordship, then the audit itself is in challenge, Lordship. In that case, the audit itself is in challenge because on the basis of some unknown information, a show cause notice cannot be issued, Lordship.
Why?
Lordship, there has to be something which has.
You have on your own submitted your audit and given it to them.
Lordship, it is
And
not
this
the
is what
case.
is being found.
It is not the case, Lordship.
No, can you say that you can't look into those aspects? And that too when it is a case of revenue.
Lordship, there is no such
Even the
power. There is no such
Constitution,
provision.
even that constitutional bench judgments out there say, even in respect of illegal search, you can look into those documents.
Lordship, the point is that if that is the case, Lordship, I have done my self-assessment by way of my returns. And on the basis of those returns, this show cause notice has not been issued.
On the basis of some audit you have done,
Some audit.
pursuant to the directions given by the Assistant Commissioner. You have submitted one, again you have submitted the second. You shouldn't have submitted.
That
But
is
you
a mistake
have done it.
which has
In
been
fact, the
done by-
client didn't meet you at that point of time. So
Maybe,
that-
Lordship.
otherwise it would have been different thing. Now, the second time you have submitted, now from the second audit, they find out that look here, these are the things which comes to light. And as such issue this. Now, what is wrong with it? How can there be a jurisdictional issue under 73?
Lordship, because this right did not accrue to them prior to GST, Lordship. This is not an absolute right that they can audit anyone or they can issue a show cause notice under section 73.
This provision is there for 73 is there. They can issue a show cause for this.
Lordship,
Recovery.
but they didn't do anything prior to introduction of GST to exercise this right.
So
There is
are
no
you
right.
saying that the 5 years which have been mentioned out here in the Service Tax Act, which ended out there, that 5 years gets eroded out there? That
No,
is why my
I'm not-
specific first question is.
I'm not saying that, Lordship.
Then
I am saying, Lordship, for exercising this right of invoking extended period of limitation of 5 years, there has to be something done prior to introduction of GST. Because this section 73.
that is why my specific question, Mr. Counsel. Let us assume your first show cause notice was not there. Or let us assume let us assume that you have submitted your return on the year 2016 as per your best judgment. No problem. Then they ask you to give an audit. You give an audit. Let's forget about the second one. You give an audit in the first one.
Prior to introduction of GST.
You give an audit. Nothing is found. Are you saying that later on, if they get an information on certain other materials, they are stopped in view of section 73 to exercise the power under 73 after the GST coming? This will lead to a serious thing. That can't be the provision.
I'm not saying on that point, Lordship. My point is that the basis of that information is this audit, the second audit. And this second audit was started or conducted after introduction of GST. Had it been before introduction of GST, that my point is they exercise this right of getting into my things for invoking section 73 after introduction of GST. If had that been done prior to introduction of GST, I would not have challenged it. But the problem is that they exercise this particular right after introduction of GST.
Let us assume that they have on 29th of June 2017 asked you to look here. We ask you to submit your verification audit without exercising 72, similar in the manner which they have done. And you submit the audit. And while submitting the audit, there's something seen out there. To look at that this is the amount which is there. when the chartered accountant points out, or whoever it is. Because if you see the access to information under 5A, it says many other person, even that the departmental audit committee also can do it.
Sure.
No, they do it and find out that look here, that this amount has not been shown, although he has submitted his best judgment and all. Or self-assessment he has made. So then in that case, are you saying that the audit having the knowledge, the materials having come into light only after 1/7/2017, that audit, the exercise of power under 73 can't be done?
Example which you gave, Lordship, in that if the second audit letter had been issued, say on 29 June 2017, now they have exercised this right of asking me an information on the basis of which they can ask for recovery, either under section 73(1) or, Lordship, there is one more provision under section 73, which is subsection 3. They can intimate me that you, on the basis of an audit or something, they can intimate me that you have this liability and you paid, and then don't issue a show cause notice. If I pay that liability under section 73 and 73(3) and section 73(4). So my point is, Lordship, if that has been done, if this right has been exercised prior to 2000, say on 29th of June 2017, then my argument fails, Lordship. My whole argument is because they exercise this right after the introduction of GST. No,
So
what
that-
is saved
that is not permissible.
no, what is saved is the right, and that right has to be exercised, Lordship. If the right has not been exercised, Lordship, then that can't be saved. Lordship, as you say, with your permission, Lordship, I'm relying on a judgment of the Gujarat High Court. But to substantiate my point, I'm relying on a judgment.
Yes.
Lordship, this is the sales tax judgment, page number 49 of my compilation, Lordship. Para 25. Para 25. Lordship,
How is this relevant?
Lordship,
This is of 2012.
Lordship, I'm just on the ratio.
Hmm.
Lordship, para 25 explains that in
To
the sales
recall
tax-
in the sales tax 19, a reopening of an assessment was permitted when the commissioner had reasons to believe that any turnover had. In such case, if there are any element of concealment of the- Yes,
Your Lordship, in this particular instance, under the sales tax regime, it was 8 years to issue the reopening notice. Then it was reduced in the new law to the 5 years. Now, para 36, Lordship,
36 of this judgment.
of the judgment.
Hmm.
We may recall that the petitioners had filed the returns at the relevant time under the sales tax act. Such returns were also processed as per the provisions of the said act. Now here there is a slight distinction because in sales tax there was a process of assessment, while here is a self-assessment. Till the sales tax act was repealed by the VAT Act, no further action was taken by the department. To be precise, no notices for reopening such assessment were issued till the sales tax act was repealed. It is true that the sales tax act permitted for the period of 8 years from the end of the period to which such turnover related for issuance of the notice of reassessment. If the commissioner had reasons to believe that the dealer has concealed the sales tax, such sales or materials, particulars thereof, or knowingly furnished the incorrect declarations or return. However, in our opinion, mere right to issue notice within the said period cannot be equated with accrual or incurring of any obligation or liability. If the notices were already issued, it may have been possible for the department to contend that the SSC, having already been visited with such notices, their ability.
So here the Madras High Court held that if period within this 8 year, though they have a right to issue the notice within 8 years, but till the repealing, if no notice was issued, then that provision cannot be invoked. That provision could not be invoked.
I didn't get it.
The Madras High Court, you see, earlier it was 8 years.
Lordship.
And after amendment, it was 5 years. So here must have been, the question involved was whether the period of assessment will be 8 years or 5 years.
Lordship.
The Madras High Court held that, look here, it is, as you have not issued any notice prior to the repeal, you don't get the benefit of 8 years. You'll get only the benefit of 5 years if it comes later on.
Lordship.
So, meaning thereby, then after the act has come into force, whether a parameter provision under 73 is given,
In
100% there will be.
the GST law. Lordship, that is there.
So then wouldn't they have the jurisdiction then under the GST? If we let us assume that this is right. If no notice has been given, nothing has been done,
Lordship.
he may lose the right out there. But then wouldn't the GST Act will take care of that?
Lordship, because under the GST law.
But the investigation, just for example, I don't think the Act could have said that you make a self-assessment on the last date. Just for example, on 25th of June, I'm saying just 25th of June 2017, you make the self-assessment. And you submit your return. Thereupon, within 5 days, they may not be. They have not issued any notice.
Lordship.
But what is the recourse then available to the commissioner?
Lordship,
Are you saying that the commissioner would not have then also power to look into it at all?
I have no answer to that question, Lordship, but here the situation is slightly different, Lordship.
You are a
That
counsel
particular
from,
period is
you are a counsel from where?
Delhi, Lordship.
Fantastic. When it is convenient for you to get an answer to that?
Lordship, there is a similar cases which are pending before the Delhi High Court, Lordship. They are
That's
listed
okay.
on 28th of this August. If you may give me a date after that, I'll just, because I'll get into the details of those particular cases. Probably I may get an answer to your question in that way, Lordship.
No, we will fix it on 29th of August.
Lordship, 29th is a bit difficult. Next day is Raksha Bandhan. If you can. First week of, maybe 4th of September, Lordship.
31st of August.
Oblige, Lord.
List the matter on 31st of August. The matter has been heard at length. This court also finds it relevant that for the purpose of adjudication of the instant writ petition, the records pertaining to initiation of notice, the records pertaining to the notice dated show cause notice, demand comes show cause notice dated. What is the date?
Is May 2009. Just a minute.
Dated 7/5/2019 also would be required to be looked into. So under such circumstances, the Mr. S.C. Kyle appearing on behalf of the GST department. GST department is directed to produce the records as sought for. List the matter for further hearing on 31st of August 2023.
Lordship, may it kindly be partnered with it.
It will only come before me. The interim order passed earlier shall continue till then. Because you see, the issue boils down to that question only. Let us have an example that 2 days before the coming into effect of the act, you submit your self-assessment. What is the right left? Are you saying that he can't exercise 73 then? It will have a serious consequences. And I don't think so. It couldn't have.
Lordship, I'll get back.
Because if that is so, then anybody who has filed the last date, and he must have, if, just for example, there can't be a best judgment done.
It's a particular difference, Lordship. Because my point in this particular case is that there was already an audit which was been conducted.
Forget about the audit. That audit is not an audit which is recognized under here.
Lord. Oblige.
Petitioner died and we have substituted them.
You were allotted land.
Yes, Lordship.
What is your name?
Soyed Ali Mullah.
The
Lordship.
House approved the settlement proposal for the land measuring 1 bigha 2 kata 8 lesser. Then what happened?
Page 36, Lordship. That is annexure 8, Lordship, SDALC meeting, and page 36, the relevant portion, Lordship. The allotment proposal of land measuring 8 others, your Lordship, got the middle portion, Lordship. The allotment proposal of land measuring 1 bigha 2 kata 18 lesser covered by that.
So they said that only they will allot you 1 bigha.
Yes, Lordship.
Then
Then, Lordship, allotment was again sent for approval, Lordship.
Hmm.
Page 38, Lordship, annexure 9.
then
Then I made an application on annexure 10, page 39, Lordship. With due respect, I have the honor to state that an order was passed on 29/1/2011 and again on 29/9/2014 to allot land at Alamganj Part 9. My humble prayer.
now you want only 1 bigha
Yes, Lordship.
and that has not been done.
No, Lordship. No
Yes.
allotment certificate was given.
Who is there? Oh,
Lordship.
madam, you are there.
For land policy, deputy commissioner has power to allot 1 bigha allot.
Then why nothing has been done?
Lordship. Most probably under the wrong notion, it was again sent to the revenue
Then
board, Lordship. Sorry, revenue department. It can be, Lordship.
what happened?
under the 89 rule,
Now, nowadays you can give 1 bigha.
yes, no,
Nowadays,
nowadays half a bigha. After this 2019,
2019 land policy.
Then what happened?
but this is prior to that 2019, whether it will be 1 bigha
Before
or
that
half
land
bigha.
policy, lordship, writ petition was filed.
Huh?
Before this land policy, lordship, writ petition was filed. And according to 1989 land policy, lordship, page 44, lordship.
No, that is there, but as of now, that
It's a
land
half
policy
bigha.
is no longer there. You get your instructions on this. From a perusal of the materials on record, it transpires that the Subdivisional Land Advisory Committee had in its meeting dated 29/1/2011 had recommended that the petitioner be settled with a plot of land measuring 1 bigha 2 kata 18 lectures. The said minutes of the meeting was forwarded to the Principal Secretary to the Government of Assam, Revenue and Disaster Management Department by the communication dated 17/8/2011. It further transpires that subsequent thereto, in another meeting held in the office of the Deputy Commissioner Dhubri, it was observed that as per the land policy, as per the then extant land policy, the land which can at best be allotted was 1 bigha, 0 kata, 0 lectures. In spite of that, nothing has happened, no land has been allotted to the petitioner for which the petitioner had approached this court. It further reveals from the records that in the meantime, it further appears from the submission of Mr. H. Sharma, the learned counsel appearing on behalf of the Deputy Commissioner, which Deputy Commissioner? Dhubri,
Lots.
that the said land policy of 1989 have now been substituted by the land policy of 2019,
19.
whereby instead of the maximum maximum area of land that can be allotted is 2 katas 10 lectures.
Okay.
Be that as it may, this court directs Mr. H. Sharma, the learned counsel appearing on behalf of the Deputy Commissioner Dhubri, as well as Ms. P.R. Mohanto, the learned counsel for the revenue, to apprise this court as regards the status of the proposal for allotment of land to the petitioner and to what area of land the petitioner would be entitled for allotment. So, this is the matter again on 11th of September.
Lordship, we were already possessing 1 bigha of land, lordship, since 2000.
Understood, but in the meantime, the matter has happened like this.
Lordship.
If the I have fixed the date. If it doesn't happen again, you may have another land policy in 2025.
Lordship.
Item 5.
Item 11 September.
Yes, Mr. Roy. What are you challenging here?
The building permission lordship granted by the Karupetia Town Council.
In your favor?
No, in favor of respondent number 7.
And why are you worried?
Lordship, there was a suit is pending for specific performance of the contract.
because the respondent number 6, he was the owner of the land. He entered into an agreement for sale of the land to me, to the petitioner. But subsequently, he sold during the pendency of the suit for a specific performance of contract. He sold the land to the respondent number 7. And then Lordship, this is respondent number 7, obtained a building permission only for a plot of land measuring 12.5 lessons G plus 6 story lot, which is not permissible, Lordship, under the building bylaws, Lord. It was not notified it yet. Notified.
So you did not file a injunction application
I
before?
had filed, Lordship.
Then what happened?
That was rejected.
So you are now on some other reasons here.
No, that is a different, a specific suit is pending. Injunction-
Why haven't you got an injunction out there? No, not to build any, create
That
or
suit was only
make any
confined-
construction over the land matters. That would have been solving the problem. That don't
No, no,
construct the land.
that injunction was filed, Lordship, but that was rejected.
But tell me whether you stay nearby
Yes, I am just adjacent.
to
I am
that
the
plot of
agreed-
land.
Yes, at a common boundary. Mr. P.K. Kalta is representing the private respondent number 7.
Who?
Mr. P.K. Kalita. He is not.
Where is it mentioned that you stay nearby?
Yes, sir. Lordship, may I come to page 21.
Are you going to show it from the agreement that you stay nearby? There's not a single statement out here. How are you affected? You have not been able to get an injunction before the trial court. Now you're before this file a writ to circumvent all these things.
No, Lordship. Here,
There's
Lordship.
not a single statement. Kindly see at paragraph number 9. Why you have filed it, paragraph number 11, why you have filed this. Filed a writ petition. Mr. Sheikh, that matter with yours, I've asked them to file a representation. You and Mr. Bhattakur were there, no?
My lord.
There I have asked you to file the representation within 1 month from the date.
30 days, my lord.
30. Because if you don't do it, can't be kept for long. Huh?
My lord, only on downloaded copy I have found, my lord. But one thing has been done, possibly by the stenographer, that the name of the petitioners are not typed out. Only in Bhattakur's case, my lord, name of the petitioners are given.
No, if you get the certified copy of the entire thing, you have not got the certified copy, everybody's name will come.
Yeah.
In the order, if you take the certified copy, everybody's name comes.
But I have
That is why that day I disposed of one matter by one judgment. The judgment was 45 pages or say 50 pages.
Right.
But if you take the certified copy, it is 500 pages because rest are all petitioners' names.
Right.
Your name will come. So, circumventing.
This petition was not filed by me. It was.
Then
uh,
you all these things you raise out there. You have already a suit, get all these things.
But Lordship, here your Lordship may please.
This court is not going into it. You have not got an injunction. You apply for an injunction, you have a suit pending regarding specific performance of a contract that you have an agreement of 2015 that land was not sold to you and sold to somebody for which you have filed a suit for specific performance. Now, during that period, they have sold the land to somebody. Now he is trying to get an injunction there. That would have solved the problem. Then instead of doing all these things.
No, that will completely change the nature and character of.
Oh, you get an injunction.
Lord. Lord.
You want that observation? I can give it
No,
to
no,
you.
I am not for.
That the petitioner would not press the instant petition and instead file an injunction application taking stay.
Here in the present.
But this court would not, unless and until you are affected, you stay nearby. How are you affected? Why should I take into account you because of the fact that you have not been able to get an injunction, you are moving the risk?
Lordship, in the 2001 Supreme Court decision, Supertech, the building, twin building, which was demolished by RDX Lordship. There the Supreme Court let down even a person not having any interest, any citizen can lodge complaint, Lordship. 2021 SCC, 10 SCC, phase 1 in Super. So whatever your Lordship has suggested, that is not correct. That is my humble submission, Lordship, that a person must have the.
Then you let them make the building. Thereafter, we will resort to RDX.
Lordship, our land measuring 12.5 plus a permission cannot be granted for G plus 6 story building, Lordship. And no norms were complied with, Lordship. Your Lordship, I have stated in details in my additional affidavit, Lordship. What are the violations, Lordship?
Not necessary. Why should I look into all these things unless you have any grievance out there? You can't say. Because you see, you are resorting to a public law remedy after having failed to get an injunction before the trial.
Lordship, may we please to peruse the.
Not necessary. That gives you, if I don't peruse, that gives you a good reason for moving the division bench out there and say that this court did not peruse. Why do you spoil your chances out there before?
There cannot be a condition, Lordship, that the petitioner must be aggrieved or he must be a never, Lordship. That is the let down by the apex court, Lordship. Supertech judgment, Lordship.
Supertech is a case where nearby all the residents who were there, they were being affected because of that area, which was specifically reserved for what you call for land, for park and all. These lands have been allowed to be where they have allowed the 63-story building to be constructed. That is the ground. This has nothing to do with here.
Apex court has.
Here is the case. No, first and foremost, you have to show your bona fides when you are moving to 26. You have failed to get an injunction before the trial court. You did not appeal against that, or appeal if you have done, that must have been dismissed. Now you are resorting to all these things. Why should this court at all get an injunction out there before the trial court? That they are making a construction. And I think the trial court will definitely consider that aspect. Bring all these aspects before the trial.
That is a suit only for a specific performance of contract. Court is to see go by the contract executed between the petitioner and the respondent number 6. Because court has nothing, there is no single aberrance regarding unauthorized building, Lordship.
Can't you amend it?
Huh?
Can't you amend it? Because after that the sale has happened. Now can't you amend it?
No, it can be that will completely change your Lordship welfare. That will completely change the nature and character of
Why?
the suit. Because my suit is only for a specific performance of contract in respect of 12.5 acres of land.
Mr. Roy,
Amendment will be
in a specific performance of a contract, if somebody wants to build a building or during the pendency or repair, the suit has been done, the property has been transferred or alienated to a third person, why you would not be entitled to an injunction?
Lordship, I had filed the injunction application only restraining the defendant number 6 from transferring the suit line to the respondent number 7. That in suit or injunction petition is confined to that extent only, not beyond that. If I amend the plan, that will 100% change the nature and character of the plan. Lordship. There was a total violation of the as building has not been constructed as per the National Building Code. No setbacks have been left. And
Setbacks with you.
uh,
Does it affect you?
certainly, look.
How?
I-
Where is the statement that you are nearby?
No, nearby question does not arise, Lordship. Already have placed before your Lordship this super take judgment.
You protect judgment, facts are not applicable. What to do? Dismiss,
No, Lordship,
wait, pause.
that I leave to your Lordship, but Lordship, I could not do my homework properly because I have reached from Pinchukasted after midnight. So I could not do my homework properly. If it is taken on 16th or 17th, Mr. P.K. Kalta is also not there.
Not necessary. I am passing the order in his favor.
I leave it to your Lordship because, or if it is taken on 16th, I will be able to do in a.
The learned counsel appearing on behalf of the petitioner submits that he had not gone through the brief properly and as such seeks for an accommodation. List the matter again on 28th of August.
Problem.
At number 6.
Yes, what is this matter about?
I want to give a response number 5 and 6, Lordship.
Huh?
Response number 5 and 6, Lordship, in this case. So, Honorable Court has directed me to pay the money, but I have communicated to my client about this order.
What is the amount? What is the case?
This is, Lordship.
This is the higher charges.
I charge this, sir.
Then
I'm the mother-in-law, Lordship.
shall not be issued to recover the higher charges illegally received by respondent for hiring. How can these courts look into this? Tell me. 6. You 6.
5 and 6, Lordship.
Then who you received the amount?
Lordship.
And the amount pertaining to what?
According to Lordship, a traveler bus, Lordship.
Huh?
Traveler bus, Lordship.
You got the money from whom?
From the petitioner, Lordship. Petitioner, Lordship. I'm
You
5.
got the
5 and
money from the
6.
petitioner or the government?
Lordship, actually, that vehicle was hired by me, Lordship. Power of attorney was given to me, Lordship. I'm the mother-in-law of the petitioner, Lordship. And subsequently, Lordship, that I have made an affidavit to respond number 6, Lordship. And money was transferred to respond number 6.
Then
That is the case, Lordship. And now, Lordship,
you got the money.
I've got the money, Lordship. And later on, Lordship, this power of attorney was cancelled, Lordship. Withdrawn.
The vehicle belonged to the petitioner.
Petitioner, Lordship.
The petitioner gave you a power of attorney.
Power of attorney.
And on the basis of the power of attorney, you gave it to respondent number 6.
6.
Respondent number 6 got the money.
Money.
And now he wants the money from the respondent number 6.
5 and 6, Lordship.
The money has already been released by the government.
Government, Lordship. And Lordship, may kindly
The
see
instant writ petition has been filed by the petitioner. To recover the higher charge bills which have been received by the respondent number 6 for hiring the vehicle bearing registration number AS02/E9811, which is owned by the petitioner. It being an admitted fact that the amount has already been received by the respondent number 6. This court finds no reason why the extraordinary jurisdiction under Article 226 of the Constitution needs to be exercised in the instant case. It is a inter se dispute between the petitioner as well as the respondent number 5 and 6. Under such circumstances, the instant writ petition stands dismissed. However, the petitioner is at liberty to file appropriate proceedings for recovery as per the ordinary as per the in the civil court, if so permissible. And
Your Lordship, since I'm appearing for respondent number 4 and Transport Department is wrongly reflected as a party here, so
next,
my prayer is to strike out our name from this matter.
I have disposed it. You want to give your name, put it in the slip.
7.
Obliged.
Yes.
May I please respond? In this case, my lord, for release of my contractual bill of rupees 6,547. My lord, this is the issue of 1992. He has worked between 1992 and 2009, my lord. RTI application is, my lord, I have annexed, my lord. That is page 12, RTI application, my lord. And they have given us the statement also, my lord. Statement is at page 13 and 14, my lord. That is list of contractors of chronological order under the head of accounts of maintenance. So
What is it? List of under contractual maintenance. What is the petitioner's name?
Bashiruddin, my lord. That is in respect of a petitioner, my lord. His name is at clause 7, my lord, annexed 2. Name of contractor. Column 7, my lord.
Huh?
Column 7.
7.
Yes, my lord. Name of contractor.
But Mr. Counsel, when have you approached these authorities? Have you ever demanded that you should be paid the money? Where is it?
In fact, I have not submitted any application, my lord, before the authority, my lord, but I have submitted the RTA application regarding the admissibility of my amount. Against this, they have given me the statement, my lord, and accordingly, I have approached to put this honorable court. Since the matter, the bills are pending from 1992 to 2009, my lord. Almost 17 years, my lord. My lord, 2 quick points, my lord. We haven't filed affidavit, but my lord, just on law, my lord, I'm just submitting, my lord. First thing is that, my lord, these are all different work orders, my lord. Yes, clubbed together in a single writ petition, whether that is maintainable. And second thing is, my lord, period of limitation. See is what if it is a pending even, my lord. It's now 17 years. He hasn't approached us. He has come before this court. So, my lord,
17 years?
That is a submission, my lord, that he has completed the work.
30 years.
30 years, yes. And second thing is, my lord, if you go by this Tamsarali judgment, 3 years, and we will maintain a list, my lord, chronological list. That is what I understand from the list. And accordingly, when fund will be, my lord, available, we'll keep on paying. So that is what is, my lord, Tamsarali, my lord, has laid down. So, my lord, so now, my lord, my first thing is that this writ petition is not maintainable because he has clubbed so many work orders in a single writ petition. These are different amounts, my lord. He should have filed separate writ petitions. Different work orders, my lord. For rupees 586, my lord, and for rupees 1,600, I have filed, my lord, separate writ petition, and that is their RTI application, my lord.
You want this court to make a reference as regards Tamsarali that the law may not be good. You have only agreed in Tamsarali.
Yes, my lord.
The issue which arose by Tamsarali happened is one court say, that look here, beyond the limitation, why should this court at all entertain? If it is not permissible as per law, otherwise, can he take? You went out there and said, look here, let us not go into a.
Yes, my lord,
Then
that is the remand. So my lord will give you some time. I will file an affidavit, my lord. We are yet to file an affidavit.
absolutely not necessary. Don't spoil your time in all these things. The instant petition has been filed, seeking a direction upon the respondent authorities to release the pending dues of the petitioner in respect to various contractual works amounting to rupees 6,547,000. From the perusal of the materials on record, it reveals that in respect to various contracts, there has been certain dues, balance dues, wherein no payments have been made to the petitioner. The petitioner accordingly submitted a RTI application before the Public Information Officer, the Executive Office of the Executive Engineer PWD, Silchar and Uttarakhand Territorial Road Division, Silchar. To the said application, the Public Information Officer of the Office of the Executive Engineer PWD, Silchar and Uttarakhand Territorial Road Division have submitted a statement wherein in respect to various contracts, the petitioner is entitled to a petitioner after having received various amounts is still entitled to an amount of rupees 6,547,000. Mr. Arthur, the learned counsel appearing on behalf of the petition, the respondent PWD submits that although the said document on which the petitioner has applied, has filed the instant writ petition, is a document being issued by the Public Information Officer of the Office of the Executive Engineer PWD. But as per the judgment of the full bench in the case of Tamser Ali versus State of Assam, reported in I'm giving so and so. It is the chief engineer, isn't it?
Yes, my lord, chief in the head of the department.
Is the chief engineer of the department concerned who has to admit to the said dues. And as the said dues have not been admitted by the chief engineer, the said no writ ought to be issued in the instant case. This court has given a due consideration to the matter and is of the opinion that taking into account the information so given to the petitioner to the tune of rupees 6 lakhs, that if the petitioner is entitled to an amount of rupees 6,547,000. The same aspect needs to be verified by the PWD authorities and more particularly by the head of the department what is the division? Verified. Needs to be verified by the chief engineer.
Chief engineer roads.
Roads? By the chief engineer
roads, my lord.
Huh?
Chief engineer
By the
roads.
chief, are you sure?
Yes, my lord.
By the chief engineer roads, and be verified at the level of the chief engineer roads. And upon such verification, if the petitioner is entitled to any amount, the said amount needs to be paid in terms with the directions so passed by the full bench in Kamserali. Accordingly, this court therefore disposes of the instant writ petition with a direction upon the chief engineer roads to make verification as to whether the petitioner is entitled to the amount of rupees 6,547 as per the statement so given by the executive engineer PWD Silchar Uttarbond Territorial Road Division Silchar. And upon such verification be carried out, if it is found that the petitioner is entitled to, the same be paid in terms with the directions so passed in Kamserali. The said exercise of verification be carried out within 1 month from the date of service of the certified copy. Only verification.
My lord, I'm just giving the retail number. Retail number.
No, don't give retail now. It is reported.
Reported, my lord.
Give that. It is no? We know it.
My lord.
It. Oh yes. Now, yes. What do you want?
My lord, we need one.
What is this matter about?
Lordship, in this matter, Lordship, a purported bill was issued to me, Lordship.
Hmm?
Counting a purported bill of electricity bill was issued to me, Lordship.
Of 33 lakhs.
Of 33 lakhs on the basis that, Lordship, I have tempered the meter. But the fact of the case reveals something else, Lordship. In 2014, the meter was seized from me. And in 2000, sorry, Lordship, not 2014.
Understood, Mr. Counsel, but it's a provisional bill. This is done under 129.
137 maybe, Lordship.
Hmm?
Yes, Lord.
So the provisional bill, once it is given, you are asked to show cause. You have given a liberty to assail and say that how much it is to be done. Have you done that?
Lordship, I filed appeal also, Lordship. I filed review also,
The
Lordship.
appeal will be later also. You have done that. Then you file your appeal also.
Yes, Lordship.
Then review also.
Always rejected, Lordship.
Huh?
Always rejected, Lordship.
So now you are before this court.
Yes, Lordship. And
Why should this court look into all these things?
Lordship, in my humble submission, Lordship, what is it calling from, Lordship? It's a provision bill, and as per the provision, Lordship, I have already paid, Lordship, 25% out of 33 lakhs, and also paid addition 3 lakhs, Lordship.
But the
as per
total amount is 33 lakhs.
33 lakhs, Lordship, but that amount is disputed, Lordship.
Huh?
I dispute that amount, Lordship.
So how can this court decide the dispute? Tell me. Give me a good reason when the provisional bill is there.
Lordship.
You have only challenged the provisional bill
Yes, Lord.
and what?
The petition, Lordship.
Where is the final bill?
Annexure E, Lordship.
No, where is the final bill? Final bill?
No, Lordship, they have not issued any final bill.
There has to be a after the provision. Yes, Mr. Borua.
Hello.
There is no final bill. Provisional bill is first made immediately after the inspection is carried out. And then you have the right to reply, and after a hearing is done, then they will issue the final bill. Against the final bill, you have a right of reply, appeal under 111 or 127, whatever it may be. Isn't it?
Yes.
Well,
I've challenged a provision.
how can the court look into all these things? Whether there is 1 meter, 2 meter and all these things? Mr. Chowdhury, so and so, the appellate demand is absolutely illegal and therefore even it deserves. Contending that he has already deposited, I have considered the how can this court decide? Tell me. Opposing the deeds submits that it is a clear case of unauthorized use of electricity by the petitioner and therefore no interference with the impugned order is called for. Also submit that even in this petitioner should have been directed to deposit another 25% of the demand since it had failed to deposit 50% of the demand at the time of admission. After the provisional bill, there is a final bill.
Right.
Where is the final bill?
My lord, perhaps Lecture E of the writ petition. At page number 24.
And he is enjoying. Yeah. APDCL
But upon payment, your lordship.
is in bad shape.
My lord.
Yeah. There is a stay. Where is this?
It's not a bill, your lordship. It was data.
As per the testing report dated so and so by replacing the existing year, that existing damaged cabinet has been replaced. The withdrawn meter sealed and taken for laboratory testing area. Where is the provisional bill?
My lord, at page
Provisional bill is in the previous annex, your lordship.
Huh?
Provisional bill is a page in 22.
Page?
22, your lordship. The previous page, your lordship. It's a type copy, lordship. The original is in page 23. Kindly come to the last portion, lordship. Total payable amount 33,76,095.
Why do you say this to be provisional? Because against a provisional bill, you don't file an appeal. That is what I am saying.
In my.
Yes, Mr. Burua,
in my-
you are not aware.
my lord, if my lord peruses page 25, it has been mentioned, my lord, under the heading objection/appeal.
Huh?
Page 25, my lord,
Hmm.
under the heading objection/appeal.
Hmm.
After receipt of the notice by memo number 547 dated 19/1/19 on 23/1/2019, the consumer prayed for providing a reasonable time for preparation of appeal against the order dated 19/1/2019. The same was forwarded to higher authority and a date was fixed for hearing on dated 8/2/2019 at 11 a.m., where consumer was asked to present all the relevant documents. On 6/2/2019, consumer placed and written appeal to the undersigned. Then the consumer stated.
Electricity Act conduct.
And in my humble knowledge, your lordship, I have not got that notification, lordship. While seizing the meter, lordship, a technical person also should be present, lordship. The manner, the arbitrary manner that they have issued the provisional bill, that's what I am challenging, lordship. The arbitrary manner, lordship.
You see, it is only against the final order. Appeal lies under 127, not the provisional bill. You see, kindly see. See, 126. If on an inspection or any place or premises or any of the so and so is found, connected or used, and after inspection is done in so and so, is indulging in unauthorized use of it, he shall provisionally assess to the best of his judgment the electricity charges payable by such person or so and so. The order of provisional assessment shall be served upon the person in occupation or possession or in charge of the place or premises. The person on whom the order has been served under subsequent shall be entitled to file objections, if any, against the provisional assessment being so and so, who shall, after affording opportunity of hearing, pass a final order. It is the final order you challenge it in appeal.
Yes, ma'am.
Has the final order been passed?
Actually, they said that they pay for time. That's why I didn't come prepared. Your lordship have it on Monday, my lord. Today, to be honest, I'm not in a position to assist your lordship.
Because as of now, there cannot be a provisional bill.
Yes, ma'am.
Whether the final order has been passed, it is, if you see 127, it is the final order which is being, you can challenge. You can't challenge the provisional bill.
And my lord, from page 25, it appears that they were given a hearing and then.
Therefore, did you pass a assessing authority? Did it pass a provisional final order or not? If it is not done, all this exercise goes for useless. Where is the order being passed after the opportunity being given?
Also, we have challenged the seizure procedure also. Because, my lord, it was not done before us. Everything was done behind our back. The procedure prescribed is, at least we should be present.
No,
The
that
meter
is,
was replaced without our in our absence, and they did nothing for 3 years. All of a sudden, my lord, they served the bill. Notice was issued.
My lord, we will put our stand in our affidavit, my lord. And
Let them file their affidavit shortly. The impression I
we are
was
filing
given
it
on-
today.
My lord.
We are filing it today.
No, my lord, we need one week's time, my lord. It has gone for vetting.
or 2-3 days time may be
This
given
is
to
a
us for
matter of
reply.
2021 and we still, there's an interim operating from 8 to 2021 and you are not interested.
No, my lord,
Yeah.
we are interested.
I'll record it.
My lord, may kindly grant us 1 week's time. to
No,
file
I'm
the
granting
affidavit.
you one, but it is, this is what is the state of APTCL. It reveals from the records that the instant repetition has been filed challenging a provisional assessment bill dated 19/1/2020, the order dated 9/6/2020 by the appellate authority, as well as the consequential order dated 25/1/2021 directing the petitioner to make payment of the amount within 15 days. This code, it appears that the total amount so claimed by the APTCL authority is ₹33,76,095. This code by an order dated 8/2/2021 state the provisional bill subject to payment of ₹3 lakhs.
No, my lord, while filing the appeal, we paid 25%.
Had state the subject to payment of 3 lakhs after taking into account that another 25% have been deposited at the time of filing the appeal by the petitioners. It surprises this court that in spite of the stay order operating, the respondents APTCL have till date not filed any affidavit in opposition. Mr. A. Burua, appearing on behalf of the APTCL, seeks for an accommodation of how much?
1 week.
Of 1 week to file the affidavit in opposition. List the matter again on 30th of August. The affidavit be filed by 22nd of August. Thereafter, the petitioner would be at liberty to file in reply.
Obliged, my lord.
9. Interim order passed earlier shall continue till. Yes. Mr. H. Sharma.
Lordship.
Is entitled to higher charges.
According to our instructions, Lordship, the amount has already been paid to the petitioner.
You have wage instruction.
Yes, yes, yes.
The instant writ petition has been filed by the petitioner being aggrieved by the inaction on the part of the respondent authorities in not making payment of an amount of rupees 14,60,814, being the total amount to which the petitioner is entitled to on the basis of the vehicles hired from him. Mr. H. Sharma, the learned counsel, appearing on behalf of the respondent police department, had submitted that the total amount as claimed by the petitioner, no,
No, Lordship,
that the petitioner have been paid, that after making due verification,
Yes,
the petitioner have been paid the following amounts. The details are given here in under. এই যে table এখন আছে। He submits that there is no further amount so payable to the petitioner. Taking into account the above, this court, taking into account the above, that the payment have been duly made to the petitioner. Nothing survives in the instant writ petition, for which the instant writ petition stands closed. The instructions so submitted by Mr. H. Sharma during the course of the hearing is kept on record and marked with the letter X.
Lordship, sorry to, I taken indulgence in document item 45.
Huh?
Item 45,
45?
Lordship.
Yes.
We have an instruction to withdraw this writ petition. So
45? What does that matter?
it is regarding no confidence. No confidence because it is against the petition.
You want to withdraw it? You're the petitioner.
Lordship, petitioner has written letter to withdraw this.
The learned counsel for the petitioner, 45. Learned counsel for the petitioner submits that he has instructions to withdraw the instant writ petition. Why?
That I do not know, but yes,
As learned counsel for the petitioner submits that he has been instructed by the petitioner
but later.
to withdraw the instant writ petition. Accordingly, the instant writ petition stands closed upon withdrawal. Yet kintu as Dr. নাম to Didibodi, advocate for the PNRD. You give your name.
10 and 11.
11 to 11 to 5.
Less visible.
My lord, in this case, the husband of the petitioner was a vendor, my lord.
Huh?
Vendor, my lord. He supplied the material to the department, my lord.
Then you are the
I am the wife of the petitioner. Husband was vendor, my lord. He supplied.
Vendor?
Vendor, my lord.
ah,
He supplied the material to the department, my lord, for requisition of the department, my lord. Scheme was under MG and recommend. Scheme was under MG and recommend. There is no provision for engagement of a contractor, my lord. Petitioner husband was simply supplier. He supplied the materials, my lord. After the material was supplied, my lord, the supply bill was verified by the junior engineer, my lord, and it was submitted to the block development officer. My lord, kindly have a look at details procedure, my lord. I have stated in paragraph page 6, my lord, how payment are made, my lord. Only two paragraph, my lord. Page 6, my lord.
page 6.
Page 6, my lord.
Yes, tell me. After necessary sanctions the scheme for execution of the once the scheme gets administered, the block development officer allows work to the junior engineer of the block. He submits his requisition block to the soil for providing materials. Whether the money issues to have supply order, the rate to supply the requisite materials at the motorable place of work. The client then supplies the materials to work with. When the site where the consumer will receive the same apportionment payment. The renewal also reflects on the back side of the bid. The meeting of the renewal in the bills are paid between the who after the groups name of him. The company which we recommended that Yes, who is appearing here? Enrega. Who is to pay?
My lord, a video, my lord. My lord, already a bill has been uploaded in the website, my lord.
I've seen it. Now, who is to pay?
My lord, video, my lord.
Video?
received-
Who is paying for the video?
Lordship.
Ultimately, Jilla Parishad, my lord.
Huh?
Jilla Parishad, Chief Executive Officer. And
So we have to get the PNRD.
yes,
Where's the PNRD council? PNRD is there. Chief Executive Officer, Hailakandi Jilla Parishad.
Hailakandi, my lord.
The-
And Block Development Officer, Hailakandi, my lord.
He is going to pay.
Yes, my lord, a bill was uploaded in the year 2017, my lord. First FTO was done, my lord. A video verified the bill, my lord. Then, my lord, as per the instruction of the video, my lord, the bill was uploaded in the website after first FTO. First FTO is first process, my lord. Then, my lord, since 2017, my lord, every crores of rupees has come, my lord, but the hard payment has not been made because he could not fulfill their demand, my lord. That is
What demand?
demand, my lord. They have fixed some certain
Percentage?
percentage.
Oh, the serious public. Yes, Mr. Sharma. There's
Lordship.
very serious allegation upon
Lordship,
your
whether
officers.
he has mentioned all these things in the
No, but
petition or
it's-
not, but in that case, Lordship, but we have received an instructions
Ah.
from the Chief Executive Officer, Jilla Parishad, Hailakandi, written to the District Development Commissioner, as stated by the BDO, Hailakandi Development Block, as per record, the payment could not be made by the then authority of Hailakandi Development Block as because the scheme was inquired by the inquiry officer and submitted comments as work as per provision in estimate is found to be incomplete. No further payment is required.
What? No,
The estimated work from the sentence, Lordship, it seems that the
no,
estimated.
no. First of all, he was, you see, as per the scheme, what it is, as he states,
Yes, Lord, supplied.
as per the MREGA scheme, it has to be done by the department themselves.
Lordship,
But for doing it, you need some materials.
Lordship,
So the materials he supplied.
Lordship.
And after supplying it, you do your work or not, that is immaterial. But he has supplied the materials.
Lordship.
Then why is he not entitled to? It is not a contract work which was given to him. He was asked to supply, he has supplied it.
Lordship.
You file your affidavit.
Lordship.
And who are you?
Lordship, I'm appearing on behalf of Mr. N.K. Devnath for Standing Counsel PNID. My lord, he's on legs in court number 5.
So?
My lord, I'm not aware of the facts, my lord, if Lordship will allow the matter to be taken after some time.
No. We'll fix it on 11th of September. On that date, you have to file your affidavits by both of you. You have to file your affidavits by 31st of August without fail.
Lordship.
Same matter both.
Same matter, my lord.
the petitioner here, petitioner in both the writ petitions are same and are agreed and is agreed by the inaction on the part of the respondent authorities in not making payment of the bills as regards the supplies so made by the husband of the petitioner. This court have taken note of the records and have seen that in the month of February 2021, notice has been issued, but no affidavit in opposition has been filed. This court further finds it relevant to observe, take note of the submission of Mr. H. Sharma upon instructions that as per the inquiry complete and conducted, it was found that the work was incomplete and as such, the bill has not been released. The learned counsel for the petitioner, however, submits that the petitioner was, the husband of the petitioner was not engaged in the, was not engaged to do the construction works. The husband of the petitioner, being a departmental supplier, was asked to make supplies, and those supplies were duly affected, which have been duly acknowledged by the executive engineer, junior engineer, as well as the block development officer. However, the said amount has not been paid. Taking into account the above this court deems it proper that the respondents needs to file affidavits, thereby bringing on record their states then. List the matter on 11th of September. Lead both the matters on 11th of September. The Panchayat and Rural Development Department, as well as the Deputy Commissioner, who? You are for whom? He.
The respondents,
The Block Development Officer.
1, 2, 4, 5, and 6.
The block shall file their respective affidavits by 31st of August without fail. The petitioner thereupon shall be at liberty to file reply.
Perhaps extra copies have not been supplied on it. Extra copies supplied because no letters have come in. This matter was listed way back in 2021. And there is not a single communication made from our end.
Next. Well, internal. Mr. Counsel, give one copy to them. Yes, Mr. Sharma, what is
My
this
lord,
case?
this matter relates to eviction. My lord, the order of state eviction was challenged before my lord district and second judge. And against that, my lord, the state petition is preferred. So affidavit has been.
Not necessary. What is this affidavit business out here?
My lord, yeah, I am appearing for the respondents, my lord. My lord,
You are saying you are challenging an order passed by the district judge?
Yes.
Why? What is wrong with that order?
My lord, this is the order passed, my lord, initial order passed by the state official under the, my lord, Public Premises Eviction Act. My lord, so far this, my lord, case is concerned, the petitioners are occupying a land that is not disputed. Whether it is a railway land or whether it is a, my lord, this is not a permissible, my lord, occupier, and they fail to. But definition of the, my lord, Public Premises Eviction Act is not fall within the petitioner's, my lord, occupation. My lordship may kindly see the definition of the public premises facility. Section 2 E, my lord.
Tell me.
Public premises means any premises belonging to or taken on lease or requisition by or on behalf of the central government, and includes any such premises which have been placed by the government, whether before or after commencement of the Public Premises Eviction of Unauthorized Occupant Act 1980, under the control of the Secretariat of either House of Parliament, or providing residential accommodation to any members of the staff of that secretary. My lord, lordship may kindly see then the text of the case of the petition. My lord, lordship, the page 20 is the.
No, what is your stand?
My stand, my lord, the petitioners herein, they were occupying the land, which is, my lord, the abortor land. And before, my lord, coming to the railway headquarters, before establishing the railway headquarters at Malikgaon. Before establishing the railway headquarters at Malikgaon, they were the, my lord.
Maybe that's a different thing. But I'm asking you whether the land has been allotted to the railways.
No, the land which are the occupation of the petitioners are not railway. It is a abortor land.
How do you say so?
My lord, that was the, my lord, plea taken by the petitioner in before the state official, and there is no demarcation of the land. Whether it is railway land or, my lord, this is not that, my lord, the petitioners are occupying some quarters or any land which is belongs to the railway. My lord, that has not been described in the notice also, my lord.
Where is the notice?
Page 15, my lord.
Page
15 of the writ petition. Annexure P1.
Yes.
Lordship may kindly see the schedule. Plot number so and so, plan number so and so, at East Bhutanagar, under cadastral DAG number 495, Moses Jalukbari village, East Bhutanagar, measuring an area of more or less 55 into 45 square meter, and bounded as all sides, nothing by that. That boundary is not being.
Where is the Jamabandi for this cadastral map 495?
I have the place, my lord,
Jamabandi?
before that, may I make a submission, my lord, that I will come to that answer, my lord. So far, this question is concerned, my lord, whether writ petition lies against the order of the district judge or order passed under section 9, or, my lord, it should be a civil revision, my lord, under 227 that has been, my lord, already decided, my lord. In the case of, my lord, 2018-15 SCC, my lord, 356 LIC versus Nandini J. Saha, my lord. There, my lord, Honorable Supreme Court has held that no, writ petition does not lie against the order of the district judge, order passed under section 9 of PP Act, my lord. The remedy lies under 227, my lord. Revision should be filed and revision lies. So this is being the writ petition, my lord. In my humble summary, according to this judgment, my lord, para 58 and 59, writ petition is not maintainable, my lord. This is the case.
To the next point of cadastral map.
Yes.
This writ petition I will convert to 227. Then your problem is solved.
Yes.
Next. Where is the cadastral map?
My lord,
Whether 495 DAG number is railway land. That's all. That is the short question. What else do you look into?
my lord, the 35 page 35 of the impugn order, my lord.
I'm not on that. Where is
Yes.
that map? Give it to me. And there must be a Jamabandi.
Yes.
The record of rights of DAG number 495.
My lord. My lord, let me file through an affidavit, my lord. This.
Let me give it to me.
Yes.
You want the eviction or not? That is the only question
Yes,
looked into.
My lord, that has been answered by the court below, my lord, also.
Whatever may
Annexer
be.
2, my lord,
He's saying it to be perverse, no?
my lord.
That's all.
No, my lord, on the other hand, I have gone through Annexer 1, the Sita copy of the disputed land, which shows that the land belonged to railway. My Sita copy, that too has been written as a railway. Further, Annexer 2 is the site plan showing unauthorized structure of plans on railway land. Annexer 3 is the trace map shows that the allotted land, railway administration. So, my lord, that has been decided, page 35, my lord. Annexer 1, 2, and 3, my lord.
Yes, Mr. Sharma. It shows it's a Sarkar government land, railway land.
Railway land, yes. My lord, and page 35 also, my lord, the judgment.
All are tag number 495. All
Even
these
if it is admitted, my lord, it is the railway land, my lord, tag number 495. Whether the portion of the land which my lord, the petitioners are occupied.
entire tag number 495 is railway land.
My lord,
Do never. 2 o'clock I'll deliver the judge.
God bless. Origin kita kinda may take back drill. So.
Lord, if your lordship, my lord, go to the, my lord, order pastel and learned district and sitting judge. My lord, page 33. I would like to draw your lordship attention, page 34, last paragraph. From the LCR, it is revealed that appellants have been occupying the railway land without any lawful authority or permission from the railway administration for about 60 years. As per my lord submission, they were, my lord, residing in the same plot of land before the railway, my lord, has been established here at Malik. And as such, my lord, since last about 70 to 75 years, my lord, there was no disturbance, no, my lord, whisper that they were unauthorized occupying the land. Suddenly, my lord, this proceeding has been initiated under the.
You are saying to be Devotor land. Is it the land? Are you saying that this particular land was taken over under that act by which the government had taken it?
That I cannot say at present.
Then-
Even if my lord, that is admittedly, my lord, admitted that my lord, this railways belongs to the railway. After coming into force 1953, my lord, railway headquarters has been established here, my lord, in Malikon. Well, prior to that, they are residing. And since last move, my lord, as per my submission, it is about 70 to 75 years. And as per record, my lord, learned district judge has said, my lord, since last 60 years, my lord, they are occupying the same plot of land residing here in my lord. This is, my lord, reveals from the record as has been perused by the learned district and district judge.
Then
Where they will go, my lord, after that long period of occupation.
so what to do?
That's the problem.
You have to go. There's no way out. What is happening in the Supreme Court as regards those railway eviction lands?
My lord.
What is happening in the Supreme Court as regards railway eviction land?
Yes, my lord.
What are the directions being passed? Pursuant to the Gujarat High Court judgment, what has happened thereafter?
Lord, latest position, my lord, that I have to take, my lord, latest.
Hmm?
Latest information is not available, my lord, right now, my lord. My lord, yeah. Otherwise, my lord, his case is that my lord, 40 to 60 years. My lord, my lord, it is his person before the court below, my lord, page 34.
Hmm.
He himself stated before the court below, my lord, that 40 to 60, first two line, my lord.
Last paragraph, it is, my lord, in that, from the LCR, it is revealed, my lord. LCR were called for by the learned district and session. As per LCR, it is revealed that the appellants have been occupying the railway land without any lawful authority or permission from the railway administration for about 60 years. It is not our, my lord, person, my lord. Our version is we are occupying the land more than 70 years, my lord, about 75 years.
No, it is not necessary, Mr. This particular document which you have
Yes,
given,
yes.
there only it is mentioned that a
Yes.
person is being residing out there, a few except a few. Santosh Saha, he is being 3 years and all.
Yeah.
Most of them have been residing since 1973,
Correct.
81. One person, namely Lokhi Bosho,
Yes.
is residing out there for the last 70 years.
Yes. Correct.
So what to do?
My lord, here, my lord, it appears, my lord, as per the, my lord, if lordship directly come to the my order at page 35, there, my lord, the consideration before the district judge was that, my lord, after going through the, my lord, Sitha copy, annexure 1 there was, my lord. Sitha,
There is no quarrel.
yes, Sitha, as per Sitha, my lord, this is
Mr.
the,
Das, there is no quarrel with the fact that the land is
railway
a
land.
railway land.
my lord.
This court is not
Yes,
on
yes.
that.
Yes.
But what to do? How do you take care of this situation? You want to throw them out, then where will they go? A
My lord,
person who have been residing.
because, my lord, as per this act, my lord, the settlement, resettlement, that is not the.
You cannot,
yes,
not on the
we-
basis of
yes.
resettlement, but
Yes.
you see, there are certain observations being passed by the recent Supreme Court judgment against that Gujarat High Court which went.
My lord.
I forgot that. I gave it to Mr. R. Pujari was there and another few person, na? N.J. Gogoi. Who is he? He's also from railways, na?
Yes. My lord.
That was the judgment which I have produced. So there the Supreme Court says had given some time for their eviction and they were doing some business, so some amount is to be paid because you can't settle them.
No, my lord,
The
yes.
settlement, if any, has to be done by the government because you won't obviously settle in your land, that is railway land. And railway land is also a public land. So under such circumstances, it is also the people, the direction also, it is required to be evicted. So what type of order can be passed?
First of all, my lord, they fail to, my lord, show that this is their, my lord, legally they were, or without, with some license or permission, they are sitting over the land. There is nothing on record. So they are not licensed.
That
They
is
are,
admitted, my lord. We are, my lord, deciding without any authority. but
yes.
prior
So,
to that-
You
so
see,
far, my lord, yes.
no, Mr. Das, this is your document which was relied upon. You can go ahead. This is the document which was looked into.
Yes.
Now kindly see those persons who have been in possession. This is a document signed out there in 2016
Yes, my
by your officials,
lord.
thereby admitting that these people have been there in possession for such long
Yes,
years.
a long period, my lord.
They have been constructing houses over the lands.
Now, most of them have been, my lord, evicted, my lord. My lord, some or one or two order from the honorable court, stay order, is another thing, but all of them have been issued the notices.
As per my
Yes,
instruction, my
yes.
lord.
No,
Apart
no,
from
this is
these
correct.
petitioners,
Yes.
there are some persons who did not approach the honorable court and they were also not evicted as yet.
No. The
So this
thing
is
is
the
that
malab-
you have to be evicted. It is okay, but
Yes.
you get hold of that judgment
But
because there also something has been given for rehabilitation. What is to be done?
oh.
They have to go out. There is no quarrel with that.
And my lord, in my humble submission, since they are, and their initial ground also, we are the permissive occupier. So therefore, railway cannot evict us. That question goes now. Now, entire Doug is as per the Sita, my lord, this is the railway land. So that is also not in dispute. He also does not dispute that this is not railway land. My lord, he does not dispute that I am the encroacher therein. And therefore, my lord, on merit, my lord, this petition cannot succeed, my lord. This is,
Definitely,
yes,
you're right.
yes. And moreover, that as per the judgment of the Honorable Supreme Court, my lord, that I already placed. If it is converted to 227, another thing, but there also the order passed under section 9 by the district judge was challenged before, and order was passed. This is ultimately challenged before the Honorable Supreme Court. The Honorable Supreme Court said that order passed by the district judge while exercising power under section 9, it is not personal designata. This is the exercising the power of civil court. So in that case, not 226, one person has to applause under 227 in my lord revision. So in both the count, my lord, repetition is my lord liable to be dismissed. My lord, I place the judgment, my lord. The land which is under
Very well.
of the petitioner, my lord, is a hilly land. My lord, it is the border of my lord, Devotor land and the railway land. My lord. Paragraph 58, 59. Now here the question was, my lord, in paragraph 4.
Where? In this judgment?
Yes. Question was in paragraph 4, my lord, in page 369.
What did the Supreme Court do?
Yes, 58, my lord. 402. I don't know.
No. These I know. I'm not
so
on
far
that.
that, my
What
lord,
did the Supreme Court
remain.
do? Impugn judgment of division
That is-
bench
this-
merely
this-
went
this-
on to this journey on his phone in front of the extent of analysis. Finally say paragraph 65. You see, what you are saying out here, if I was the lawyer, I would have never insisted on this. But you want, I will. The Supreme Court says that the exercise of jurisdiction may have been 226 or 227, whatever may be. Taking into account that a repetition has been filed, whatever.
Yes.
This should have been construed to be an order passed under Article 227. And as such, the division bench could not have exercised the powers of later state.
Right.
And the division bench having exercised their power, because against 227, the latest patent doesn't lie, that is wrong. And as such, division bench judgment was set aside. However, liberty was given.
Liberty is there.
No. Liberty was given to these people to challenge the single judgment in the appropriate forum, means 136.
Yes.
This is what the Supreme Court did.
My lord.
Until 6 weeks, nothing is to be done.
Right.
Now, I am in a stage where I will be exercising 227 again.
Yes.
Now, if I exercise 227 out here, then what is the problem?
No, that's correct, my lord. That can be converted. Because, my lord, there also petition was filed under 226, read with 227. original petition, my lord, challenging the district judge order.
That is why I'm saying,
Yes.
yeah, he may have done it.
Yes.
But the fact that the matter has been pending out here from
Yeah, yeah.
2021,
Mal.
this court can very well direct
Yes.
that this to be under 227.
My
Now,
lord,
moment I say it to be 2007, there will be a change in nomenclature. And the order which you were supposed to get, you won't get it now.
my lord, moreover, they had the matter on merit.
Who?
So, my lord, this matter, my lord, the now present deliberation.
Who has heard?
No, my lord, lordship was hearing this matter present petition.
Absolutely.
So
But you
therefore,
are insisting on
No.
that judgment.
no,
what
while
to do?
passing the final, my lord,
You
otherwise,
were only insisting. I didn't insist.
even in on merit also, my lord. So, my lord, there is no wrong, my lord, committed by the learned district judge in my humble submission. So,
No,
therefore,
district judge did not commit any mistakes. There's nothing on there. But for this court, now in view of that judgment, I have to ask the registry to re-register it.
yes,
And thereby he's saved. Now it will be a matter of bench one. Okay.
so,
Mr. Mr. B.K. Das, the learned counsel appearing on behalf of the railway, have drawn the attention of this court to the judgment of the Supreme Court in the case of Life Insurance Corporation of India versus Nandini J. Shah and others, reported in 2018-15 SEC 356, wherein it was observed that an order passed under Section 9 by the district judge in under the provisions of that an order and an appellate order passed under Section 9 by the district judge in exercise of the powers under the Public Premises Act 1971. No repetition, repetition can be entertained under Article 226. He submits the petitioner ought to have approached this court under Article 227 of the Constitution. I perused the said judgment in the case of Nandini Jesa Supra, and I'm also of the opinion that the instant repetition ought not to, the instant repetition is not maintainable under Article 226 of the Constitution. Accordingly, this court, taking into account that it is a case of life and liberty of the life and livelihood of the petitioners, this court directs the registry to re-register the instant writ petition as a proceedings under Article 227 of the Constitution and list the matter before the court.
any time order passed, my lord,
The interim order passed earlier shall continue and I'll list the matter
immediately after.
and list the matter
On a particular
on
date. my lord. Yes.
13th of September
Yes.
2023. The interim order passed earlier shall continue till then.
Obliged.
It should have been otherwise disposed. Yes, Mr. Sharma.
Yes, sir.
Timing item 1.
One.
What happened? What did the SP do?
Lordship, I have received a report.
What is the stage of investigation?
No such any progress. If your lordship go by this
Why? Nothing.
report, your lordship may kindly go through that report, lordship. The present petitioner, Lordship, is the local guardian.
Hmm?
The present petitioner is not the father. The person who died, he was not the father, Lordship. He was the local guardian. And from the report I have gone through, it seems that both the girls are staying along with their parents, Lordship, but their whereabouts are not traceable, Lordship. So one special investigating team was constituted.
Now, Baba Chan, but you see, if you kindly come to the third page,
Lordship.
in between, further on, no, in the meantime, there's a last but not
Yes,
last,
when the IO tried to communicate.
with the complainant to know some more facts, the complainant's son, Rajamani Singh, revealed that the complainant had expired in the year 2020 and accordingly he submitted the death certificate. Who is Brajamani?
Rajamani Singh is the son of that present petitioner.
And the present petitioner is not the father.
Uh-huh.
No. He's the local guy. I have to bring details. I don't know. The Projamoni is son of that petitioner or not, I don't know. But I have to correct the instruction. Because I don't think that
As because no, from this, yes,
Brajamani
the
is there.
complainant's son. Complainants means the person who lost the affair. Annexure 16, Lordship. Let me check as because this is not very legible. This
Who is the complainant?
According to my instruction and petitioner is the complaint.
affair.
Are you the father?
No, I am the local guy.
Yes.
And who is, and you are appearing for whom?
Wife, my after
Of?
death, since wife of that writ petitioner. Death writ
Of the complainant.
complaint.
And these girls were staying where?
I don't know anything, my lord. Being wife, because it's a matter of Silchar, my lord. We are staying at Guwahati. This is a matter, subject matter, whatever it is a matter of about Silchar, my lord, in Qatar.
And what was your husband doing?
Husband after retirement, he has gone to native village at Qatar district.
He was a joint
That time,
director.
that incident, I think, whatever the information he has made, I think during after that, when he was staying at Silchar, nearby Silchar in the village, native village. That time this thing has occurred. I think. Otherwise, we, the family members, we are staying at Guwahati. Now, what complaint, that's why I wonder what complaint he has made, that also we do not know. After coming to know that a proceeding is going on after his death, so for that I have filed an implement petition so that the matter may be closed because the person has already, we do not know anything about the subject.
It's okay. For you, it's okay. He may not, because he may have done it in his interest, taking into account those two girls have been missing.
Lordship.
And that is a crime which have been committed. And
Yes.
from the inquiry reports, it is a fact that the girls have been missing. There is no quarrel with that.
Yes.
It is an admitted fact. It is the thing that in spite of trying to trace out, they have not been able to do so. So the question of closing the writ petition at that behest doesn't arise. Maybe he is dead, but taking into account the incident, the crime has been committed, this court can
Even
very
if
well.
the writ petition is closed, Lordship, that criminal case cannot be closed.
Hmm.
That will continue.
The criminal case, no. The matter, as the investigation has been proceeded on the basis of the instant writ petition.
Lordship. So
And
let
this
it be
court
kept.
would not like to close it. with this.
Yes.
Dekho. And you bring the entire documents.
Lordship, keep it as a part of the record, Lordship. I have one copy.
No, not this. Not this thing. You have to give me the entire thing. What is this?
The annexures also. Lordship.
Read this.
I got it in the WhatsApp, but not legible. Lordship, may kindly
And
give me some more time.
because of this court directing that the SP has to be present, so it is dated 14/8.
Maybe, Lordship, but I personally contacted him and obtained this instruction.
And that is why he signed it now.
No, our letter, Lordship, most probably that is on 14th/8.
Your letter today is 14/8.
Yes.
Then when did you write the letter?
No, Lordship, you are requested to furnish the required instructions with regard to the progress of the investigation in the form of a report in connection with so-and-so on or before 14th. Lordship, but even then, Lordship, I will produce the whole record. The annexures, Lordship.
And my lord,
Mr. A.K. Purkayastha, the
my lord,
learned
kindly
counsel.
kindly have a notice, my lord. The Babachan Singh, the deceased petitioner, was the complainant. He was the complainant.
You are the complainant?
Yes, sir.
Yes, I understand. Yeah. Mr. A.K. Purkayastha, the learned counsel who was representing the complainant, the petitioner submits that the petitioner expired in the year 2020. Mr. B. Sinha submits that he had filed an interlocutory application being the wife of the petitioner, wherein it has been mentioned that the wife of the petitioner has no objection if the instant writ petition is closed. Be it as it may, it is seen from the records that pursuant to various directions being passed by this court, some sort of investigation has been carried out pertaining to Lakhipur PS case number 190/2012. It is further seen from the orders passed by this court on 6/6/2023 and 6/6/2023, 15/6/2023 and 19/7/2023 that the SP, the Superintendent of Police Kachar, was directed to submit a progress report in respect to the investigation so carried out. Today, Mr. H. Sharma, appearing on behalf of the Superintendent of Police Kachar, have placed a report of the Superintendent of the State Authority dated 14/8/2023, which is the said report placed before this court during the course of the hearing does not include report does not include the annexures mentioned therein. This court have also perused the said report, which shows that there has been certain attempts being made to trace out the victims at Manipur with the help of the officer in charge of Parampat PS. It further reveals that efforts are on to trace out the victims and apprehend the accused persons to draw an inference into the case. Next. This court have also duly considered the submission of Mr. A.K. Purkayastha, the learned counsel, who submitted that the petitioner had expired, and as well as also the submission of Mr. B. Sinha, who appears on behalf of the wife of the petitioner, wherein it has been mentioned that the wife of the petitioner wants a closer to the instant writ petition. As observed earlier, the instant investigation, the investigation to the Lakhipur PS case number 190/2012 had progressed on account of certain intervention made by this court. At this stage, to close the entire proceedings on the ground that the petitioner had expired and the wife of the petitioner does not want to proceed with the writ petition, would not be in the interest of justice, taking into account that a crime has been committed. Under such circumstances, this court fixes this matter again on 6th of November 2023. Full stop. The SP, the Superintendent of Police, Kachar, is directed to file the report dated 14/8/2023 along with all its documents and closures, as well as also give an update as regards the present, as well as also give us update on the present stage of the investigation, or update of the investigation as on that date. The said affidavit be filed by 31st of October without fail.
And I will continue, madam.
Mr. A.K. Purkasta, the learned counsel submits that he, taking into account that a crime has been committed, he would like to assist the court as an amicus.
May I get back that copy?
Huh?
May I get back that?
Let me, you have a copy?
Yes, I have a copy.
Taking into account the said submission, this court, this court also finds it appropriate to appoint him as an amicus, taking into account that he has been aiding, taking into account that for the last so many years he has been assisting this court in respect to the instant proceedings. The registry shall show Mr. A.K. Purkasta named the learned counsel as an amicus.
God bless you.
You give a copy of the report to him.
Yes, Lordship.
13.
This is a petition against the order of the district judge's election tribunal, my lord, or a punishment election. Yeah, my lord,
What is this matter?
my lord. it's a-
Election
Election, my lord.
of,
Panchayat election, my lord, of 96 Paschim Hauli Gaon Panchayat constituency. For
then what is your ground?
my lord, the recount was ordered, my lord, without deducing any evidence, without taking into account, without framing any issues, my lord, without taking into account whether recount was permissible or not. If my lord may come to the impugned order.
Proceeding is pending.
No, my lord. In the recount, my lord, my lord, I have been shown as the private respondent has been shown to have secured more votes in the recount.
You are a private respondent.
I am the return candidate. My
Oh, he got more marks.
My-
So therefore, his election, the election has been set aside.
my election was set aside.
Now,
By my lord, if my lord comes to page 20, sorry, my lord.
you got a stay.
Yes, my lord.
Then page,
Page, my lord.
who is appearing for the private respondent?
Mr. Gugoi was appearing.
Who is appearing for the private respondent?
I'm appealing for private.
Yes, what is your stand?
Lordship, after hearing both the parties in the learned court below, the recall proceeding was called for, thereafter recounting done, Lordship. And in recounting, we proved the majority, Lordship. Thereafter, learned court below selected as a winning candidate, Lordship, and issue a certificate, Lordship.
So you are now the winning candidate.
Lordship.
So, and Mr. Nair, your case is
My lord, there
that
was
how can a recount be given?
without hearing, without the material facts being, my lord, pleaded, my lord, without a hearing on the material facts, my lord, without adducing any evidence.
Didn't he allege in his election petition that the accounting was wrong?
My lord, if my lord comes to the election petition, my lord, at page 40,
Page,
40, starts at page 40, my lord.
for that the year should have been declared formally as the AP member, for that the returning candidate attitude or in his attitude by not showing the doubtful and rejected votes to the counting agent of the petitioner and not adding votes out of the counting of the votes was illegal. Oh yeah, ground number 3 is there.
My lord, counting of votes was illegal, but my lord, no, it was, my lord, the complete facts were not disclosed, my lord, in this petition. My lord, it has to be supported by concise and precise allegations. Those are not there. My lord, at page, para 3 of this petition, my lord, page
After
41.
counting of the votes, it was calculated the petitioner obtained total iman and her contestant.
Respond number 3 is the petitioner.
The respondent obtained in total so and so. In all, over 10 words of so and so. After counting of the said votes, the respondent number 1 also orally declared petitioner as the winner as but surprisingly, later on, the respondent number 1 and 2 illegally declared the respondent number 3 as the winner, as the AP of so and so from Iman, showing to be defeated the petitioner by 50 votes. The petitioner immediately applied for a certified copy of the result sheet and so and reflect that the petitioner obtained Iman and the respondent obtained Iman. As per the report of the site counting, the petitioner obtained Iman. Okay, now let's see the
There was no
judgment.
application for recount before the returning officer.
How did the recounting happen?
My lord, page 66, my lord.
Now, where's the impugn order?
My lord, impugned order, there's the first impugned order is at page, my lord, sorry, my lord, page
Civil
70.
Judge Shea was directed to recount the ballot paper in presence of the parties, and their learned counsel has submitted a report stating that the recounting was conducted on Iman and the next result of the counting. The result is signed by the
At page 66, my lord, the ballots were called for.
So from counting, it was found that 2519.
My lord.
Okay.
My lord,
Now,
before
where
that,
is the requirement that you have to go for recounting before so and so? Where is the order of recounting?
my lord, page 66, the ballots were called for, my lord.
No, where is the
My lord,
there
page
is a
77.
direction of recounting?
Page 77. It's seen from the petition that the prayer is mainly
Counsel
only
for
for
the
recounting
petition
of
respondent are present. Today, speak for passing order regarding recounting in connection with so and so. It is seen from the petition that the prayer is mainly only for recounting of the ballots. The fact of the case is based upon reports which are in the custody of the there is nothing to reject the recounting the ballot. But the learned governor who carries on the year no the election petition and petition objection considering the fact that for recounting the recounting will be done. So this order is there.
Yes, my lord.
So then,
My lord, this order, my lord, the second paragraph, first line, my lord, it is seen from the petition that the prayer is mainly only for recounting of ballot papers. My lord,
no, that petition.
yes, my
There must have been some petition filed.
my lord,
My lord,
You have filed the petition, na?
Lordship,
Then
that is page, order, that is page
order is
58,
on the what
page
petition?
58, Lordship.
Huh?
page
Page 58,
Petition is at page 40.
page 52, my lord, is for calling the ballot papers.
43 contains the prayer. Prayer is.
That's in the election petition, my lord. There was no other petition for
page
counting of
52 is the petition, Lordship, page 50.
No, where is the petition for
Page 52, Lordship,
page 52?
for recounting, Lordship.
Where is your prayer for
For
recounting?
ballot papers, Lord. Sorry,
Huh?
Lord. For-
No, this is only for calling.
Page 52, Lordship, for calling.
Then where is that? For recounting?
It's not there, my lord.
Submitted the petition contains the petition.
Only to call for the-
Recounting.
No,
of
why
the-
was this?
recount-
No, prior to 1912, 1902, there must have been some order passed.
My lord, page 66, my lord.
1902.
16/6/2020, my lord, page 66.
This 1902 is page 71.
My lord.
The learned counsel ballot papers and AI as called for has not been received. Issue reminder fixed for documents.
My lord. After this, the order dated 19.
Yes, how could this order be passed? Mr. Counsel?
And also, my lord, on the, after the recount, there is a discrepancy of votes, my lord. If my lord
No,
comes,
no, prayer is there, page 43.
43 is in the election petition.
So the prayer is there, call for the ballot papers and connected documents from so and so and order recounting of the votes for the post of so and so.
My lord,
So
that
the
is in the
prayer is there.
election petition, my lord.
Yes.
Election petition, my lord, only on the basis of the facts pleaded. My lord, after that, evidence has to be taken, my lord, whether, because that election petition, my lord, in my humble submission, cannot go in for a fishing inquiry. He has to prove his case. Only then, my lord, the recount can be ordered, my lord. Just on the basis of the petition, on the, my lord, there are certain decisions on this, if I may be permitted, I'll take. But before that, if my lord kindly comes to page, my lord, sorry, my lord, page 24. Just for a moment.
Yes.
My lord, I have made out a table, my lord,
Hmm.
Showing the second column, it's the result as per the result sheet, and the third column as per the result sheet on recounting. My lord, the total number of votes polled were 6207 as per the result of the counting. And as per the recounting, my lord, it is 6192. There is a deficiency of 15 ballot papers. Then, my lord, total number of ballot papers rejected in the counting, my lord, was 1163, which has increased to, my lord, 1196 in the recount.
Vote not valid. Total number will secure by 24.
My lord, the ballot papers cannot go missing, my lord.
So what is the difference here?
My lord, 15 ballot papers missing, my lord, in the recount. Total number of ballot papers polled or found. Then, my lord, total number of ballot papers rejected, my lord, it increases by 33. But what is the ground, my lord? Total number of valid votes, my lord, is not mentioned, my lord, in the recount, my lord.
Where the ballot papers known here?
Sorry, madam.
Ballot papers?
Lordship, LCR only call for Lordship, the LCR received Lordship.
Is the LCR is here?
Lordship.
Ballot papers not here. Where the ballot paper? But the ballot papers returned.
Maybe it is in district, recounting in, was done in the premise of district court Lordship. Barpeta. Maybe there or recount, I'm not aware.
I'm surprised. You see, 19 to 2021 was for documents. And on that day, ballot paper was received.
Fixing for 10/7/20. Non-appearance to be due to lockdown, as such case adjourned. Call for the ballot paper not received, issue reminder for the same. Fixing 16/9. Non-appearance due to lockdown and as such case is adjourned, call for the ballot paper not received, issue reminder for the that is 10/7 order 20 lordship for ballot paper. Thereafter ballot paper is 10. Case record is up today and the case complex was declared as a that is 20.
So, Mr. Nair, what other evidence you are required?
My lord. Certain decisions.
What is it?
My lord, that is a recount cannot be ordered as a matter of course. The recount has to be, my lord, after the court comes to a finding that the recount is required. My lord, in this AR 64, my lord, 1, 2, 4, I have given an index, my lord. Para 6 and 7 of Ram Sevak Yadav. Para 6, my lord, an order for inspection may not be granted as a matter of course, having regard to the insistence upon the secrecy of ballot papers. The court would be justified in granting an order for inspection, provided two conditions are fulfilled: that the petition for setting aside an election contains an adequate statement of the material fact on which the petitioner relies in support of his case, and the tribunal is prima facie satisfied that in order to dispute and to decide the dispute and to do complete justice between the parties, inspection of ballot papers is necessary. But an order for inspection of ballot papers cannot be granted to support vague pleas made in the petition, not supported by any material facts, or to fish out evidence to support such.
That judgment not in your favor. Next.
My lord, it's basically on the same, my lord. Jagjit Singh versus Kartar Singh, my lord, from para 33, 35, 36, and 37.
What is now? Finally come to this one. PKK Samuddin.
My lord, para 13, 14,
When
and
no
15, my lord.
primary case for recounting made per election held out of name, but even if person to the ceremony for the recounting is done.
It's settled, para 13, my lord, it is settled position of law that the justification for an order for examination of ballot papers and recount of votes is not to be derived from the hindsight and by result of the recount of votes. On the contrary, the justification for an order of recount of votes should be provided by materials placed by an election petitioner on the threshold before order for recount of votes is actually made. The reason for this salutary rule is that the preservation of secrecy of the ballot is a sacrosanct principle which cannot be lightly or hastily broken until and unless there is a prima facie genuine need for it. The right of a defeated candidate to assail the validity of an election result and seek recounting of votes has to be subject to the basic principle that the secrecy of ballot is sacrosanct in a democracy, and hence, unless the affected candidate is able to allege and substantiate in acceptable manner, measure by means of evidence that a prima facie case of a high degree of probability existed for recount of votes being ordered by the election tribunal in the interest of justice, a tribunal or court should not order recount of votes. Viewed in the light of these well-enunciated principles, we find that the petitioner has neither made such averments in the election petition nor adduced evidence of such compulsive nature as could have made the tribunal reach a prima facie satisfaction that there was adequate justification for the secrecy of ballot being breached in the petitioner's case. My lord, in the last sentence of para 15, my lord, we are unable to sustain this contention because we have stated earlier an order of recount of votes must stand or fall on the nature of the averments made in the evidence.
So you are saying that without evidence, you couldn't have given direction for recount.
That is my submission.
That's yours.
That is my submission.
Because here in this case, Lordship, learned court below pass a order only because of the case is
Whatever
still
may
on
be, I
record.
think this is a case for
Record.
remand. This is a case for remand. There is no evidence.
Because the case is based on record, Lordship, that's why the
Understood, but you have to satisfy. Don't you think so? You require that you have to satisfy. And as per the Panchayat Act, the Representation of People's Act
Yes,
apply.
my lord. Section 54, rule 54. Rule 54, my lord, of the Assam Panchayat Constitution. Books.
What does it say?
but they are not raise a objection during the passing of the recount, but they participate in the recounting proceeding, Lordship.
It was
They
under
they
objection.
consented, Lordship. After that, I am declared a winner. They approach this honorable court.
There was no hearing before the recount. But 54 reads, my lord, as regards other matters not provided in the Assam Panchayat Constitution.
When our petition allow for recounting,
When is the period ending?
December.
This December. And this matter is pending from 2021.
Lordship.
This should have been an urgency shown by you. Is it stay operating?
Lordship.
Then what to do? Yes, you are telling me.
My lord, as regards other matters not provided in the Assam Panchayat Constitution Rules 1995, matters shall be guided by the relevant rules under Representation of People's Act 1995.
Now, what is the rule?
My lord, Rule 54 of the Assam Panchayat Constitution Rules 1995.
I had a clipping. This is disposed of. I'm allowing his petition, remanding it back for fresh trial. We completed within 3 months. Whatever evidence can be given, you give it. That is the thing which is. 14. And the parties shall appear before which court?
District Judge, Election Tribunal,
Barpeta, Lordship.
Barpeta will be, you will appear before the court on 30th of August.
38.
30.
30.
I'll dispose of the matter.
14. Deeply obliged.
Yes, Mr. Bhatti, what are you doing with the writ against an insurance company?
My claim was repudiated by the insurance company. Therefore, I filed a complaint.
On not getting an insurance amount?
Yes, ombudsman, my lord. And that was also rejected.
Rejecting the complaint in relation.
Now, my lord, first of all.
But Mr. Bhatti, how do this court look into these aspects? Whether you are entitled to 9,77,000?
That may not be.
Then?
But so far the 8 lakh rupees is concerned, my lord. That has been determined by the surveyor. To that extent, I am entitled to.
No. Whatever may be, why it has been repudiated?
It isn't repudiated because he had taken the policy as a shop. It is shopkeeper's insurance policy. His own records, as per his accounts, it was a go down, rent. And even surveys, observations, they have gone there. And the whole location, he could not give a trade license to show that it was not a, it was a go down and not a. Documents were not there. The surveyor observed that it is clearly, it was within a jute campus, Lordship, from the jute mill.
Huh?
The shop, Lordship, which is stated to be a shop, is within a jute mill, Brahmaputra jute mills campus. There, jute mill is there. Within that, it was clearly a go down, Lordship. Photographs are there, survey report is there. And Lordship, he had submitted the accounts. Accounts, Lordship may see page 101 of the affidavit. There, his own accounts. And then, in fact, in the first intimation letter, the fruit had tumbled out. He had claimed it as a loss in the go down.
Yes, what is there?
Page number 101, Lordship.
Go down rent.
Go down rent, Lordship.
Are you saying that?
Yes,
Go down rent. And his policy
He
is
had
where?
3 shops.
What is the term of his policy?
Round the policy loss is there in page.
At
Three
page
different
29.
policies, different year.
29.
24, 3, 2022, 23, 3, 2021.
Where?
In page 67.
Page 11.
No, so serial number 667.
Now, where is this policy?
Page 29.
29.
29. Policy for shopkeepers insurance. So shopkeeper would not be entitled for this.
The different risks altogether. Categories is risks are categorized as per dwelling, shopkeepers, godowns, factories.
And since how the policy happened? Means at what time, when did you start to take the policy?
These three
For last 3
particular.
and 4 years, my lord, but so far this insurance company is concerned.
Huh?
This is the first policy. So far this insurance company is concerned, that is the first policy we obtained from the insurance. company.
First policy.
Yeah. Earlier, we obtained the insurance policy from the then.
So was it ported? Was it ported? Earlier policy, was it ported to this company?
No,
So it's a fresh policy,
first policy.
not a
Yes,
ported policy.
yes.
So therefore, you must have submitted your declaration. How did you have that policy?
My
Was
lord,
there any
because I
verification
did not-
conducted?
I did not submit any kind of proposal. The issue they came, and after verification, they issued the policy, my lord. Because they also did not produce the proposal for my lord, and according to the provision contained in my lord, so far this Insurance Regulatory and Development Authority Act is concerned, my lord. They have to forward the proposal to me, my lord. Let it be so, my lord. First of all, may I take your lordship at page 29, my lord. Your lordship will see policy schedule for shopkeepers insurance. No doubt, it is so. My lord, the nature of the trade is closed, etc.
Nature of the trade?
That is, your lordship will find in Annexus C, page 29.
Serial
Nature
number?
of the business.
Nature of the business, cloth, etc.
Closed, etc. So far, whatever has been stored there was the closed, my lord. Now your lordship will come.
You must be having your terms and conditions of your shopkeepers insurance.
Yes, sir.
Where is it?
In spite of that fact, my lord,
No, sir,
may
that
I
is the
take
file.
your
It's
lordship?
not-
May I take your lordship to para 19 and 20 of my petition? That would make the position very clear, my lord.
Where are the terms of the shopkeepers insurance?
There, my lord, may I take it at page 19, para 9.
And what is this policy? A surveyor?
That is the report. My lord, first of all, may your lordship will come to para 19 of my petition.
Yes,
May I read it, my lord?
please.
That the petitioner begs to state and contain that it is not the case of the respondent, the claim has been repudiated for non-disclosure of material fact. A material fact is a fact which would be relevant for a prudent insurer to fix the premium or to decide with the insurer to take the risk. The premium for a soap is more than the premium in respect of a godown. So there exists no reason that the lesser premium was paid and taking the risk over instead of business premises. Thus, there is no disclosure of the material fact, even if it is presumed. First of all, my lord, this being the position, my lord, and here, my lord, the main question that it was a business claim merely for the reason that in my letter claiming the compensation on 20th July 2020, I stated it as a godown, my lord.
No, understand, Mr. Bhatti. First of all, you have a policy
Yes, Lord, yes.
Shopkeeper's policy. Shopkeeper's policy will have certain things what are
Yes,
covered, which are not.
yes, Lord.
I think when it is a shopkeeper, you will be having the terms of the shopkeeper's
Yes,
policy.
this
Where is
is
that?
actually, based, Lordship may see this here. The shopkeeper's policy is one composite policy. It's like all policies have been
No,
made into
Mr.
one
Gus-
club policy.
Mr. Goswami,
So
I think better off you bring on record that shopkeeper's policy
I'll do that.
by way of an affidavit.
No, no, no.
That is the basic reason. If you come within, you see, whether you are a shopkeeper or not,
Yeah.
that is the
The
question.
shopkeeper, I am the shopkeeper, my lord. Apart from it, my lord, assuming for the sake of the argument, that it is a go down, even though there is no allegation at all that has suppressed the material fact, the premium, more premium I have paid in respect of a go down, my lord, that statement I have made. There is no denied. They have not denied that particular fact in their affidavit and opposition. Rather, they admitted it, my lord.
Lordship, they've been denying that it's not a good
No,
outcome.
no, it is not a question of denial or not. First of all, whether you fall within the shopkeeper's insurance policy.
Yes.
Because after looking into that, then we will ask, why did you not? I think
Declare it as a go down.
in the policy, you need to verify. You can't have a policy, because what happens, this insurance company, they keep on disturbing you to have a policy. Once you have the policy to get the money, it becomes a difficult thing, isn't it? You may not be having, Mr. Goswami must be.
I don't like to agree to that, Lordship.
Mr. Goswami would not, because he may not having so many insurance company within his belt. So obviously he may not, but otherwise all other people are facing. At the time of doing it, these insurance companies keep on saying, you do it, you'll get this much.
On
They don't
His
verify.
account, so that's a go down. He isn't paying 7,73,000, whereas in the other two cases, he has three policies. It's in thousands annual. Here it's he must have taken a big space, Lordship. In a go down, within a jute mill campus, big space for storage. And storage, Lordship, brings you to its own problems. There's a risk of conflagration of risk.
No, one thing. When you do a policy, you have a schedule of that particular place.
Yes. That's the address is there. Location is there, address is there.
So you must be there. You must have seen it.
No, Lordship.
No, you can't do that like
No,
this.
Lordship, I'll just explain the basic principles. Insurance can be done with closed eyes. At that time of loss, everyone will open their eyes. What is this risk? Did it exist? Someone, Lordship, today comes and proposes, I have a house in Kerala. I belong to Kerala. I'm posted here. So he'll come. He has a right to get it.
Then why have you taken the money?
No, Lordship, but that's what I'm doing. That's called utmost good faith. It's
Mr.
a principle,
R. Goswami,
Lordship.
the learned counsel,
They're
appearing on
devoted
behalf of
throughout
the respondents, shall file on by way of
Yes,
shall
I'll-
bring on record the policy and the shopkeeper's policy by way of an additional affidavit. List the matter again on 29/2023.
29.
20/9/2000.
My lord.
All right, Lordship, I'll do
JPP, JPP.
There's no other. This August is full. Then in September, first week is closed. Now we are concerned with the second week. So you want a second week? I can give you an unlucky date 13 if you want that. I thought you wouldn't like 13. So I put it on 20.
All right.
Wait, Provisional. My lord, Lordship, perhaps may not like to take this up, my lord. Because Lordship,
What?
the petitioner Lordship, he was a member of Pharmacist Forum of Assam.
So?
In the earlier round of litigation, my lord.
I had appeared.
My lord.
This is a pertaining to 32B.
This is my lord, Lordship, my license was cancelled under section 36. Section 36.
So?
Lordship,
At page 16, Lordship.
And lordship,
Of course.
What is this judgment?
lordship pursuant to this judgment, my lord. So-called notice was issued, lordship, and my license was cancelled. And
Lordship, he was asked to appear, Lordship, with audited. He was asked to appear, Lordship, page 16, Lordship.
Oh, this pharmacist forum.
lordship.
Okay. This is the matter before any other bench.
Highly obliged.
Sixteen.
May I please? Lordship, matter pertaining to ex-gratia, Lordship. Matter pertaining to ex-gratia, Lordship.
Ex-gratia?
Yes, Lordship.
For what?
For the husband of the petitioner, Your Lordship, had expired due to rotative accident. And accordingly, the petitioner filed an application for claiming ex-gratia under the notification dated 15/11/2014.
Ex-gratia for what?
For date of the petitioner.
Public place.
Yes, sir.
My lord, in this case, R4 has filed affidavit and charge sheet has been filed in this police case, my lord. It may be disposed of in directing the time frame.
My lord, in this case, we have filed our affidavit also, my lord. That's point number 1.
You're on this 15/11.
Lord.
Huh? Where is the 15/11?
At page 23, Your Lord.
Huh?
At page 20. Serial number 3, Your Lord.
15 on notification. I got it.
It's not really good. No, no.
Formula, sir.
Which the inspection.
Which one?
Serial number 3, Your Lord.
Ex-gratia.
My lord, in this matter, item number 16, my lord, we have filed our affidavit, my lord. Lordship, kindly see the affidavit of paragraph number 3, my lord. The accident took place on 31/7/2014. The notification coming to force in 15 November 2014, my lord. Lordship, annexure A, page 6, my lord. No notification, my lord. They fall under the notification dated.
So you will get 1 lakh.
Yes, my lord. 24th April 2007.
Lordship, with due respect, Your Lordship, Honorable Court earlier directed the claimant payment 2 lakh, which was also
In one case, my
accident
lord,
took
there.
place under the earlier.
Maybe, but here at that point of time, the relevant notification only came only that the revised rates shall be applicable in respect of which may occur in the state on or after the date of the notification.
Yes, Lordship, but.
So then
Lordship.
1 lakh.
Yes, lord.
এক লাখে দিব।
Obliged.
As per 2007. Huh? Only one.
17.
Next one is also similar, my lord. This is the
Hmm?
next one is also similar, my. I'm on behalf of Mr. Enrique.
Similar?
Similar, my lord, and this is the instruction regarding his payment of his entitlement of 1 lakh only. As per
Accident
24/7.
happened same.
Yes, madam.
Same. Marked as
Notification
an
applied.
X, huh? Instructions. More dictation they can. 1 lakh.
19.
Oh, these two.
My lord,
Now.
made the option.
My lord, in item number 18,
You have challenged which one?
my lord, in item number 18, I have assailed an order which your lordship
That was given without tender.
that was given with tender, but to the second highest bidder. I was above the person who was given the, my lord, offered the bid, my lord,
The period was given for what?
for one.
Where is the impugn order?
My lord, kindly lordship may first come. Yes, my lord.
Mr. Khan,
Period is over, my lord.
period is over,
Oh,
nothing
we have-
remains.
we have settled it to him. He has challenged also.
Anyway, the period is over.
Over.
So that has not been extended.
No, no, my.
Okay. In both the cases,
Yes, my.
both the cases you are appearing.
For a respondent.
It is same. Huh?
My lord, the tenure is reflected in annexure 1, page 43, my lord,
Annexure 1.
page 43.
Okay.
My lord, this is the short tender notice. That last line I'm reading, my lord. The following bills on daily basis fishing management under Assam Fisheries Development Corporation
Which bill we are concerned?
with Odadhar part 1, my lord. Number 5, my lord, bill number 5.
Okay. For the period from 31st March, for the rest of the months, only up till 31st March 2022.
22. So this period was open.
The instant petition has been filed by the petitioner challenging the order dated. Where is that order, impugn order?
Yes, my lord. Order dated, my lord, 19/7/2021.
Yeah.
At page number, my lord. On that order, we could not get, my lord, because it was not offered, given to us. And I have mentioned the number of the order because the caveat was filed. On the caveat, I could gather the order, my lord.
Challenging the order dated, has the affidavit been filed?
Affidavit has been.
Yes, challenging the order dated.
19/7.
Page 15 of my affidavit.
Challenging the order dated
19/7.
19/7/2021, whereby the respondent number 7. Dharnad, no? Dharnad. Respondent number 7 was allowed to manage, was allowed to manage the bill Godadhar Part 1 of Dhubri district under daily operation fishing management system up to 31st of March 2022. Full stop. It has been submitted at the bar that the said period, that pursuant to the said period, the order dated 19/7/2021 had not been extended. Full stop. Under such circumstances, the instant writ petition, nothing survives in the instant writ petition to be adjudicated due to a flux of time. Accordingly, the instant writ petitions has closed as infructuous.
I'm obliged.
Yes.
My learned friend is appearing.
I guess the respondent number 6 is the settlement version.
This is where this order is what?
Same order, my lord. At page 28.
Where is that order?
Page 28.
Huh?
Page 28, my lord, the settlement order.
It is same order.
Yes.
It is same order by another tender. Okay, same order itu thought. নাম কিটা খালি বেলেগ হ'ব এটো HK না তাৰ ইটো H
Item 20.
I'm on behalf of the answer. I may be allowed to withdraw this petition.
You want to withdraw?
Yes, with the liberty to press file a press.
Why?
Some necessary documents were not annexed.
What not there?
With that.
What is this not documented? When did it happen? So you will get 1 lakh.
My lord, in this case, accident was happened on 29/7/2020.
The accident happened on 25/7/2020. So you'll entitled to 1 lakh. Make verification. Huh?
It's 2 lakhs, ma'am. 2 lakhs.
Why? Oh, that was government in 2000. So he'll entitled to 2 lakhs.
But no NOK has been. Next of kin certificate is not.
So he'll submit the NOC. Submit the NOC. It is normal. Last line, the petitioner shall also submit a certified copy along with the certified copy of the instant order, the next of kin certificate.
21.
Lordship matter relates to non-payment of ex-gratia amount, my lord.
Which one? Ex-gratia amount for what?
For the death of his brother, my lord, due to road accident, my lord. As per notification, my lord, he is entitled to 2 lakhs, my lord.
How?
As per notification, my lord.
What is this notification?
15/11/2014.
Huh?
15/11/2014. Accident took place on 13/3/2000.
This is accident.
Lordship.
Yes.
How is the brother entitled to? How is the brother entitled to?
NOK is not.
NOK will produce, my lord. But brother, he's not unmarried brother, my lord.
So? Accident.
Accident, my lord.
Make verification, shall also submit the next of the kin certificate.
Lordship. Public.
22.
My dear Lordship,
Hmm.
this matter is relating to the matter stoppage of the works of maintenance work. And your Lordship was pleased to direct them. Initially, my direction was given to get the instruction whether any inquiry was made or not.
Yes, who is appearing for PNRD?
Mr. did not inform me, my lord, that he has instruction. Let me.
Now, this is pending matter since 27/10, your kind of order dated 27/10/21.
5/5/2020. Five.
27/10/21. Initial minor that order where the direction was given.
Where is the direction? 27.
Page, my order dated 27/10/21.
And the report that out of 53 numbers of scheme 39 on scheme 2018 for executing the duty and protection of status quo by the foreign or 39 of. इजे ऑर्डर लिखिए ना हो Yes.
Well, I have.
Inquiry was done. Now pursuant to the inquiry, did you serve him a inquiry report?
That instruction I don't have.
How can you impose a penalty?
We have received nothing, madam.
They have
participated in the inquiry. No, but as far as giving a copy of the report, madam, I have.
Whether it is required,
Should be given, madam, copy of the report.
then only he can oppose
Yeah.
to the inquiry.
In fact, respondent number 7 might have made a complaint. President.
Oh, again, constitution.
My lord, may I submit, my lord? My lord, the issue is that, my lord, in this.
He is the person on his delegation, my lord, type respondent.
The inquiry was initiated, my lord, as per order of dishonorable court, my lord, for a moment, my lord, dishonorable court order, page number 89 of the writ petition, my lord. I had approved dishonorable court, my lord. I am the president, elected president of the Gao Panchayat, my lord. And as per provision of the Assam Panchayat Act, my lord, a Gao Sabha was held, my lord. And in the Gao Sabha, some schemes were selected, my lord, as per MG and Raga Act and the Assam Panchayat Act, my lord. And my lord, without approving the Gao Sabha list, on the interference of the local MLA, my lord, another list was prepared, my lord, in violation of the provisions of law. And that list was approved by the my lord, authority, the deputy commissioner, my lord. That was challenged before this honorable court, my lord. The legal issue was that, my lord, whether a list prepared in violation of the provisions of law can be approved, my lord. And that was the main allegation in the earlier writ petition, my lord. And this honorable court on the very first day, my lord, directed the petitioner to approach the government, my lord, filing appropriate petition. Accordingly, the petitioner, respondent number 7, president, approached the honorable government, my lord. And my lord, the reference is there in the order, my lord, of the inquiry order, the WBC of 311. The inquiry was directed, my lord, as per order of this honorable court, whether the list was prepared, my lord, as per provisions of law, my lord. And the now issue is that, my lord, the simple issue is whether the list was prepared as per act of the provision of the MG and Rega and the Assam Panchayat Act, my lord. That was the issue. Not regarding, my lord, the punishment or anything officials, my lord. It is not the issue, my lord.
Page 92, your lordship will see, my your lordship will.
That is 55 and 75.
Yes. 55 is, madam, your lordship will.
Page
Page
55.
55, page
I'm
93.
directed to state that the petitioner so and so in
Page
the above has alleged serious anomalies in the preparation. You are requested to conduct a thorough inquiry into the matter and submit report.
No, page 92 will be, my lord, it will give some idea. Page 92.
With reference
After
to
that
the government.
contempt petition was filed.
Demand of the same maintain status and implementation of Yes. Now, why are you challenged all this?
Madam, we have come here, my lord, actually 258 during COVID period, my lord, that they were, my lord, completely unemployed. It appears in page 92, very elaborate order, my lord. Page 92, your lord, can this one. So that's why, because respondent number 7, there was a meeting, but in that meeting, some scheme was, my lord, selected, but that was not sent to the authority. So we, the elected members, my lord, along with the signature of about 600 something, we, to the local MLA, requesting to approve the authority in order to give labor or employment to those laborers, my lord, employment that is wages, my lord, the scheme has to be approved. Accordingly, my lord, after series of the exercises, my lord, it was approved. Work started. About 40 to 45% was already completed. Thereafter, my lord, they filed a writ petition, and after writ petition, my lord, it was dismissed on withdrawal, with the liberty to file an application before the authority concerned. They filed an application with giving us some time. Within time limit, it was not disposed. They came for contempt petition. After having contempt petition, my lord, this status quo order has come. Only, my lord, to save their skin, they filed this status quo order, my lord. And because of status quo order, my lord, those people who are already started work, development works, it has been held up, my lord. And now I think my learned friends also understand, my lord, will realize, because it is the panchayat and it is the public who are suffering, my lord. Because it is a dispute between the president and the members, man. And because
you are all?
We are all elected group members, man.
Of
that Saidpur Gao Panchayat. when we find that the president has not forwarded the scheme to the authority, then on the request of the people, we made a representative to the local MLA, who was the deputy speaker, madam, with a request him to take up the matter with the authority. We have not asked him to do something. Simple, our request was that, my lord, you take up the matter with the authority, let the authority do it immediately so that our unemployed person can get some employment. Some immigrant laborers also are there. On page 92, it is there on the report itself, page 92.
So as of now, it has been stayed.
Because of status quo.
Statement.
Stay.
All right. So my humble prayer will be, my lord, your lordship may only decide the simple issue, my lord, and dispose of the repudiation, my lord, regarding the selection of schemes, my lord. From that point, my lord, regarding the selection of scheme, my lord, the respondent number 7's claim was that, my lord, whether the selection on the interference of the MLA is, my lord,
That is not the part here.
uh,
Is that the part here?
of the inquiry part, my lord.
No,
I
here
have-
he has challenged.
Yeah.
These are the two things.
Yeah.
That the implementation of the scheme has been stayed.
Yes, my lord.
Now, why this has been stayed, Mr. Debnath?
Only because contempt petition
Page
was filed.
93, 92, 92, 92.
You should conduct an inquiry.
You have to, if there is some anomalies, you have to correct it. And then proceed with the scheme. If the scheme is there, isn't it applied throughout the Assam? Then why you have not done anything? Let's see what is the document, annexure 9. Read it.
Well, this is a communication made by the commissioner and secretary to the commissioner.
First page 92 on annexure 8 may be seen first, my lord.
It says that, my lord, I'm directed.
Read it.
I'm directed to state that the petitioner Tahir Barbhia, President 10, number 10, Dakhin Saidpur Gram Panchayat, in the above read petition has alleged serious anomalies in the preparation and execution of the list of schemes under the MGN Rega during the financial year 2020 to 2021 pertaining to Sonai Development Block, Kasar. You are requested to conduct a thorough inquiry into the matter and submit report immediately within 10/5/2021 to the undersigned for further necessary action.
But you were supposed to bring on record that inquiry. What is this Basir Via inquiry? Basir Ahmed Borlosko inquiry.
He was the secretary, my lord. Then
Whatever may be, have you conducted this inquiry? This is what I have asked for. You are giving me some other document. I was also thinking that when there is no order passed by this court on 5/5, why did I mention? Because my order categorically says, leaks the matter on which state Mr. N.K. Debnath, the learned counsel appearing on behalf of PNRD, shall apprise this court as to whether the inquiry as ordered by the order dated 5/5/2021 has been completed and whether any report has been submitted. You are bringing on record some departmental proceedings of somebody. We are not concerned with all these things.
as regards the allegations, when this inquiry was conducted, my lord, and
If you have anything, there is a serious anomaly, correct it and then proceed with it. These are public, these integrated natural resources management schemes. These are in public interest. If there is something wrong, some manipulations or some fraudulent elements are done, correct it. But these are schemes which are applied everywhere. Why you have collectively said that for Sonai we shall not apply? You have not got the instruction which I have asked for. This is something else.
made a communication, my lord. This was the report that was sent, my lord.
Huh?
Not a communication, my lord, when this was the report.
And how is this Bashir Ahmed has anything to do? When can you get it?
A week's time, my lord.
Huh?
Weeks.
Why? Is it where? Tahiti?
No.
Then nearby. Jonathan Bhavan. You may have a new building, it's a different thing now.
Tomorrow is a holiday, my lord, then we have.
Tomorrow, I'm not saying it. We'll have it on today, 14. We'll have it on 25th. Get your instructions on this. This court had directed by an order dated 2/8/2023 to apprise this court as to whether the inquiry as ordered by the order dated 5/5/2021 by the Commissioner and Secretary PNRD Department have been completed and as to whether any report have been submitted in that regard. However, Mr. N.K. Devnath, appearing on behalf of the PNRD Department, have placed some other documents which had no relevance to the query so made by this court. This court fixes the matter on 25th of August 2023, on which date Mr. Devnath shall obtain the instructions in terms with the order dated 2/8/2023.
My lord, may I pray for my lord listing of the contempt case, my lord, regarding this matter mentioned?
No contempt. I have no jurisdiction over contempt.
Obliged.
Item 23.
Happy, Your Lordship. My lord, in this case, my lord, the petitioner before Lordship, my lord, with the second order of litigation, my lord, they earlier approved before this honorable court, my lord, and they were heard by the learned agency, my lord, for land compensation award, my lord. And thereafter, my lord, since the authority has disbursed all the amount to the private respondent, then we approached before this court, and this honorable court is asked the respondent number 3 ADC, all the legal heirs heard, and thereafter to take decision on that matter. Accordingly, the learned ADC is heard and held that with all the legal heirs equally entitled the land compensation amount. Therefore, they have initiated process to get it.
Mr. Counsel,
My lord,
if the respondent number 5 has already received the money,
my lord.
how can you now initiate a public remedy? Why you are not going before the civil court? I'll give you the liberty. Go before the civil court.
My lord, one line, my lord, with lordship.
Once the money has already been released, if any part of it is left, I could have. But if the money has been released, I think the only way out is go to the civil court.
My lord, absolutely right, my lord. Well, in this case, my lord, well, under a round of litigation, medicinal court has recorded one line, my lord, that the respondent number 5, my lord, on perusal of the record for the found that the competent authority accepted the indemnity bond dated 2020, whereby the said private respondent, as claim indemnified declared and undertook to refund the government any amount if the same was detected as overpayment or undue payment, irregular payment made. In the light of this, my lord, this honorable court has directed the ADC to hear all the parties, all the legal heirs. Accordingly, we have been heard by the ADC, all the legal heirs, then found that the ADC is held that yes, all the legal heirs are entitled equal share, my lord. Then
Mr. Deka, you are aware. If that be so, you should have asked, this is done under what provision? No, under what provision? Which is the provision under which acquisition was done?
Yes, my lord.
Under which provision? Acquisition Act 1894
Yes.
or 64? Acquisition under what provision?
My lord, our compensation is awarded by the highway authority.
National Highway Authority.
Yes.
If you have any problem with the apportionment, are you not required to move that?
We are not.
competent
We are
authority?
not on that. We are, my lord, the authority, my lord, after hearing all the parties, my lord, why they have sanctioned that amount to the privators, why not to equally share to us, my lord? There is a lapse on the part of the authority, my lord. Why should we suffer the civil court? They will continue. Even authorities initiated process to, my lord. One or two orders I'd like to show your lordship. In my petition, lordship have a kindly look, my lord.
You are saying the National Highway Authority has done it?
Yes, my lord, ADC. Gala.
This is national, the acquisition was made for what?
Highway, Milord.
Which highway?
Foreign highway, Milord.
Huh?
Foreign highway, Milord. In
Four lane highway, then why the National Highway Authority is not made a party?
The ADC has third matter, Milord. Deputy Commission, additional DC has third matter, Milord. There is no dispute over about regarding disbursement, equal share disputing.
These are the problems out here.
We are, against highway, we don't have any grievance, Milord. Page 26 annexure for the order, Milord. ADC has got. It's 26 and 27 Milord.
National Highway.
Milord.
Kindly see 3H.
Yes, Milord. 3H4, Milord.
3H4.
Yes. Yes. If any dispute arises as to the apportionment of amount or any part thereof, or to any person to whom the same or any part thereof is payable, the competent authority shall refer the dispute to the decision of the principal civil court of original jurisdiction within the limit of whose jurisdiction the land is settled. Here, Milord, my case is actually different, Milord. Why? Already it is part and first order that we all the legislators are entitled that part compensation equally, Milord. Then despite this, Milord, the ADCS, Milord, whole amount deposited in the private respondents by banks.
Where is that order? Asked by the ADC that everybody will get it.
Page 26 of my repetition, annexure 4. Page 26, Milord. Dr. Deep permission, I'll have to read the order.
So there is a direction by the ADC to refund also.
Well, page 27, the order. And government also annexed this order, page 27. And private respondent 5 also responded, admitted at page 29 his admission.
Then?
So, Milord, now, Milord, by affidavit, Milord.
Who is paying for respond number 5?
No, Milord, they appeared, Milord, but no affidavit filed till date. No affidavit filed. My advocate Goswami, Milord. Till date, no affidavit has been filed.
Yes, madam, why did you give it to everybody? To respond number 5 in spite of having an order?
My lord, in this affidavit, it was stated for recovery from the person also. Notices have been served to respondent number 5, my lord.
Then?
But he was not yet responded. My lord.
So why did you give it? How much you are entitled to?
My lord, total to 20,70,000, my lord. We are entitled 2 lakh something, my lord, all equally. 7 to legal years.
Total how much?
22,70,000.
22 lakhs?
Yes, my lord.
No. Respond number 5 is not entitled to a single penny.
Well, out of this total amount, he'll share whatever his shares come, he will entitle that amount.
So how much you are entitled to?
Yes, my lord. I am giving.
As per annexure 4, my lord, second installment amount is 22,72,460 plus 79,000.
My lord, we all are
totaling to-
entitled, my lord, 2,94,000.
Huh?
2,94,000 equally all. Out of 23 lakhs,
Equally means everybody is entitled to 2 lakhs or
2,94,000.
all.
Everybody, each. And private.
How many petitioners are here?
My lord, here we are 2.
What about the others?
But they have represented in the before the ADC, but not before this court. They are not.
So they don't want.
They will come, my lord, and we are before, since earlier out of litigation, we approached before this court, then we have come here. And they, other legal years, ADC has heard them, my lord. Then the private escrow entitled only 2,94,000, not the whole amount.
No, but madam, once the ADC has passed an order,
Yes, ma'am.
holding everybody will get it. Why did you release the entire amount?
Hello, date of release is not stated in the affidavit. ma'am.
Huh?
Date of release is not stated in the affidavit.
No,
ma'am.
here you see, can you see here? What if you stated in your affidavit? You say, kindly see this affidavit. Your affidavit filed out there.
Yes, ma'am. Okay.
You have admitted that. Kindly see. Paragraph 7.
Yes, my lord, admission is there.
And 10 also.
This was done on 2011-2018. When was the amount released? He must have given an indemnity bond.
Yes, my lord.
As reflection in page 25 order, my lord, in earlier litigation, that is reflected. my lord.
Huh?
In writ petition, my lord, page 25, mentioning of indemnity bond is there. my lord.
Now, where's the indemnity bond?
Report from Hannah.
Oh, there. Indemnity bond is of 25/10/2018. So the amount was released before the order.
Yes, my lord.
Before this order, which was filed
Yes.
on 27/2/2020, amount was released.
Thereafter, my lord, High Court is recorded and asked the ADC to hear all the parties, and then ADC is passed this order. And except for just, I have shown your lord.
Understood.
But by the time.
But amount was already released.
Already released, my lord.
So under such circumstances,
And then,
what will they do?
my lord,
That
therefore,
is the problem now. This court shouldn't have exercised their jurisdiction. You have to get your money. I think you better file it out there before the civil court.
I leave it up to lordship, you know, which is best for lordship. Give direction.
So doesn't it become an interstate dispute between you and respond number 5?
My lord, is the already admitted to, my lord, the department has authority has left.
That becomes a proof.
Yes.
That becomes an evidence.
Now, due to lapse on the part of the authority, we are suffering now, my lord. Then we have to move against civil court and enter civil court how this thing will
Can't help it.
continue, my lord.
Can't help it.
With the left on the one,
No, you see, the other way out is this.
my lord.
The state has to pay you and the state has to recover for him, which on the basis of an indemnity, the state can't. Because that was released prior to that.
Before that order,
Ah,
yes, my lord.
that is the biggest problem.
Then also, my lord, subsequent all the orders, my lord, they have initiated process to get that amount, my lord, and private respondent, my lord, earlier on the service that was completed, he never represented before this court event.
You never, you are the
Yes, lord.
5.
Yes, lord.
Fantastic. Now something happened. Yes.
So today I'm
What is your right?
Lordship, today I missed my brief, Lordship, because I am not gone through the post list today itself, Lordship.
Huh?
Today I missed my file, Lordship.
Fantastic. Give him the second file. We'll take it up after some time. Good. Get again. It's a simple matter. You got the file. It's a big file there.
No, this is not.
We'll take it after some time.
Lordship.
Read through it. Very good. Response number 5 is there.
24.
Lordship, here in this case, Lordship, and I am appearing on behalf of APDCL, Lordship. Lordship,
Relating to what? Electrical accident.
no, Lordship. Lordship,
May I submit? Here, Lordship, the husband of the petitioner was died due to electrocution at a public. The husband of the petitioner was died due to electrocution at a public place. There is a notification of the Disaster Management Department, Government of Assam, 25th November 2014.
23?
25th November 2014, page number 29, Lordship.
That is 15 November.
15 November, sorry,
Ah.
Lordship. 15 November 2014.
Hmm.
As per that notification, Lordship, clause number 3, ex-gratia to the next of kin of person killed due to accident in public place or in public carriers. They are entitled to get an amount of rupees 2 lakhs. Here, Lordship, my submission is that, Lordship, to be entitled to get this benefit, 2 conditions are to be satisfied. The first is, Lordship, the death should be accidental, and second one, Lordship, it should be in the public place. Now, Lordship, kindly come to the FIR, which was lost by the wife of the deceased, Lordship.
Then what happened?
Then, Lordship, thereafter, Lordship, we have submitted one representation before the Deputy Commissioner, Lordship. That is at page number 31, Lordship. But till that no decision has been taken as to whether I am entitled to the benefit of ex-gratia amount of 2 lakhs or not.
Then
Thereafter, Lordship, we have referred the same petition.
electrical accident.
Electrical accident in a public place, Lordship. What I am trying to submit is that, Lordship, the date was accident, and it was in a public place, Lordship. I satisfy both the condition, and as such, Lordship, I am entitled to the benefit of ex-gratia up to an amount of rupees 2 lakhs, Lordship, as per that notification.
When did it happen? When did it happen?
Lordship, on 12/8/2019, Lordship.
As the electrical accident, have you got the money from APTCL?
yes,
Lordship. Yes.
3 lakhs he got.
Yes, sir.
3 lakhs he got.
Now another 2 here. Yes, revenue. This will open another Pandora's box.
No, my lord. So far, my lord, the matters coming up before this honorable court and which have been disposed of with regard to claiming of compensation of 2 lakhs under this notification 15/11/2014. All has happened, my lord, out of road accident. I mean to say, my lord, vehicular accident. Here is a case, my lord, where it is not a vehicular accident. It is, my lord, due to electrical short circuit or whatever it is, my lord. But lordship will kindly grant us some time to file an affidavit on that issue. Because this needs to be clarified.
No, I don't understand. You are also, because that day I was getting another matter. A person who died in victim's compensation. Person who died out of an accident. Now he is asking for under the victim's compensation also. Because somebody killed him.
Yes.
Accident. Crime has been committed. Dependent. NSS 5 lakhs there. This is another 2 lakhs. Epidicial another 4 lakhs. Tell me. If the government is in such rich, huh? Or is it something to do with anything else? What is this? That day there was one matter which I asked you to file an affidavit. Whether the nephew will become also a next of kin.
Yes.
Isn't it the government required to find out? Yes, here it is okay. Next of kin is the wife out there, she will be entitled. But you have next of kin is given very generously out there by your deputy commissioners. Anybody will come in.
Yes. No, again, my lord, the next.
I understand the government has a lot of money. India is prospering, but is it necessary to that the money has to be done in this manner? Something has to be there. Can there be a double compensation for the same incidents?
Now, my lord, so far as-
Tomorrow he may very well come under the Assam victims compensation also. He comes. There he will get 5 lakhs.
Yeah, now, my lord, this honorable court has clarified that, my lord, so far as motor accident is concerned, vehicular accident is concerned, one will be entitled, my lord, to make a lay claim, my lord, under the motor accident claim tribunal. And over and above that, my lord, this 2 lakhs. No, therefore,
No, that is motor accidents tribunal case is a different thing. That he will get it from the insurance.
yes,
He'll get it from the insurance.
Insurance.
Apart from that, your government has been so generous enough to give this 2 lakhs. So this is 2 lakhs. Then wouldn't he also not be entitled to under the Assam victims compensation? Crime has been committed. Somebody has to ration negligent driving. Somebody killed him.
maybe, my lord. Yeah. Now, again, yes, he will have to lay a claim there. He will have to lay a claim there, my lord.
There also he will get it.
Yeah, definitely.
But there he will get 5 lakhs. Where is the council? You want 5 lakhs or 2 lakhs?
No, but that amount will not be, my lord, perhaps, my lord, not be spent out of government, etc. Maybe, my lord, the one who has.
Are you saying no? Kindly see that some victims compensation.
My lord.
Crime has been committed. Somebody died. Matter finished.
This is in addition. my lord,
And
that
you
is
have
the
made it
difficulty,
minimum
yes.
5 lakhs, maximum 5 lakhs on account of that.
Yes.
So there he gets 5 lakhs.
Yes.
The serious respect.
Yes,
Now this
yes.
accident
In fact,
is
we have
due to an
already.
accident in public place.
No, this needs to be clarified. That's why, my lord, I am making
Or in
that
public
submission.
areas.
Yes, or in public areas, because
So,
therefore, my lord.
no, there might be
Yeah.
2 things. There might be an accident, just an accident by any other car, or in public areas. So if it is inside a public area, like for example, a ASTC bus, if an accident, a person dies, he will be entitled to 2 lakhs.
Yes,
But if it is a case of any accident in a public place, he gets it.
yes,
Now he says that the electrocution happened in a public place.
yes.
Now the question is, if it is an epidicial amount, Can it be said to be a public place when it is an epidicial property?
Yes.
Tell me,
So therefore, my lord, on,
ask him.
yes.
You are claiming that epidicial was there. How did the accident happen?
While he was working in a tower, and that is located at
Huh?
public.
No accident
While he was working on a tower, lordship,
of the epidicial.
of the epidicial, lordship.
So it is epidicial's property.
Lordship,
How do you say it to be a public place?
lordship, the public place, lordship, has not been defined anywhere, but lordship, while. defining
Understood, but
WBC
public
number-
place has to be public.
Yes, lordship.
How can you say it to be a epidicial? Isn't the properties of epidicial private to of epidicial?
Lordship, may I read one paragraph of a judgment, lordship, of our honorable court, lordship. I have annexed it, lordship.
What is that?
Paragraph number, page number 43, lordship. Public place, lordship.
No, this is not clear.
43, last paragraph, lordship. To be entitled to ex-gratia payment, the person must be killed due to accident in a public place or public areas, with the clarification that such death must not occur due to violence by extremists, terrorists, miscreants, or due to firing of security forces, which are covered under the different heads. As per Oxford Dictionary, so and so, public places has been defined to mean places open to public, that is accessible to all, available, free, unrestricted community.
Now tell me whether the tower was accessible.
No.
To all.
No.
Then?
The public place was public and he was working, lordship, under the instruction of the.
No, there is my lord, after
No,
this,
this will be doing something. I have no problem in giving you another 2 lakhs, but the fact that this is learned, this will be floodgates.
no, my lord, this is the decision, my lord, in Gulonata Das. After this, my lord, there are some other decisions have been pronounced by this my lord honorable court, coordinate bench. So one of such decision, lordship, may kindly see, my lord, that in fact there is a notification of the department itself defining public place. My lord, I am reading it, my lord. It says in partial modification of clause C of the department notification dated so and so, Governor of Assam is pleased to decide that the next of kin of persons killed in public places shall be entitled for ex-gratia as per norms. The word public place will mean any street, alley, park, public building, any place of business or assembly open to or frequented by the public or any other place which is open to the public view or to which public has access. Now here, my lord.
So therefore, can it be a
Lordship,
person
may kindly-
working out there? It's okay. You give me a copy of it.
My lord,
Whether a person who is working in a tower of the epidicial, can it be said to be a public place?
no,
Will have a far-reaching consequence.
yes,
Then tomorrow everybody will go or inside the substation.
yes.
Inside, there are a lot of cases where inside the substation somebody goes.
So therefore, this notification specifically says a place which is frequented by public. So this
It
is
may
a-
be a case where he may be entitled to. If it is on the road, the what do you call, the wire of the epidicial falls down, he killed, then it is a public place he will be entitled.
maybe.
But not in a case of a tower,
Yes,
where I think the tower, nobody can
Yes, no.
have access.
absolutely. So our.
I think you better file an affidavit.
Yes, that,
Mr. R. Bapujari, appearing on behalf of the Revenue Department,
my lord.
submits that the revenue would like to file an affidavit bringing on record, or rather, file an affidavit in the instant matter and bringing on record the notification dated.
My lord, it is dated, my lord. 15th October 2014.
Huh?
15th October 2014.
Was it before that?
Yes, my lord. Let me kindly see it.
No, 15th October, because
2014.
this is 1511.
1511.
The 15th October 2014, wherein the government of Assam Revenue and Disaster Management Department had explained the term public place.
In fact, my lord, in this decision, the department had filed an affidavit bringing on record that notification, and that notification has been taken cognizance of by this honorable court.
Okay, anyways,
My lord.
so list the matter on 30/8/2023. The affidavit be filed by 28. Short affidavit, because this requires.
Yes.
High level.
You going to? Oh, yes, time being. Yes, employed 23. So what is this respond number 5? You have taken the money belonging to others. Why you are not returning? You have submitted an indemnity bond.
Lordship, on that regards, sir, I have to take instructions. I have to file an affidavit, Lordship, after consulting with my client.
When?
2 weeks. Lordship.
Did you submit your so cause before the authorities?
Lordship, I will submit all these things. I have to take the instructions.
Mr. J.K. Goswami, the learned counsel appearing on behalf of the respondent number 5, submits that he would like to file an affidavit in the incident matter, for which he seeks for an accommodation of
2 weeks. Lordship.
2 weeks. Lists the matter again on 11th of September 2023. The affidavit be filed by the respondent number 5 by 7th of September 2023. This court further directs the respondent number 5 to state in the affidavit as to how the said respondent state on affidavit, as in the eventuality this court decides the case in favor of the petitioner, how the pay amount shall be refunded back to the authorities.
Obliged.
25.
Please, Your Lordship. Lordship, the matter pertains to non-performance of statutory duties both by the reviewing authority as well as the appellant authority. Lordship, what has happened? There is a certificate of public demand, Lordship, issued in favor of the petitioner bank, page 19, Lordship. Page 19. Lordship, it's an amount
Yes.
29 lakhs 27,108.
You have filed a review.
Yes, Lordship, we have filed a review, but the review authority is saying just because an departmental inquiry is pending against the Bakizai officer, Darden Bakizai officer, so they did not entertain my review application. Lordship, even respondent number 3 has filed an affidavit and they have admitted that the order was passed by the learned Bakizai officer whimsically. Lordship, he had waived an amount of 22 lakhs from the certificate amount on the eve of his superannuation.
Who are you?
Lordship, I am the cooperative Citibank, Lordship.
Your money.
Our
Who
money,
had to
Lordship.
pay?
Lordship, the judgment debtor has to pay. Lordship, respondent number
What?
5.
No, Lordship.
Who are you?
Lordship, I'm the
Respondent
respondent number
number
5.
6.
I'm the respondent number 5, the Bakijai officer at that point of.
You are a Bakija officer.
Respondent number 6 has to pay the money, Lordship.
And we are paying for respondent number 6.
If I, Lordship takes.
You waived 22 lakhs.
Lordship.
Okay. It's okay. He has waived. Now he can't do anything unless they want to take departmental proceedings against him. Anyway, your thing is that the review has not been done. Yes, who is appearing for the government?
I appear over as deputy commissioner.
Who is to review?
Lordship,
Why the review proceedings have not been decided? Does the power of review is there?
57, Lordship.
Huh?
54, Lordship. Sorry.
Of the?
Of the Bakijai, Lordship.
And when did you file the review?
Lordship, it is within time because it was an order passed behind our back, Lordship. When we came to know about the interim order,
When did you file the review?
Lordship, we have filed the review on 10/12/2019, Lordship.
Till now, nothing has happened.
Nothing has happened.
Who is the person who is interested, authorized to take the review?
Lordship, in fact, the Bakizai officer, but the ex-provider.
No, as of now, there is no Bakija officer.
As of now, there is a Bakizai officer.
Why the Bakija officer has not taken it? You are appearing?
What
What is that?
Corporation department.
Yes.
My lord, appeal has been filed before the DC, my lord. My lord, my page number 38.
And the review?
Lordship, we have prepared an appeal because the review authority did not take any decision. That's why. But Lordship, I would.
You said you have filed a review. Where's your review application?
Lordship, my review application, Lordship may kindly take for the moment page number, Lordship, 30, Lordship. It's a formal objection which we have, Lordship, filed before the assistant registrar. The matter was, Lordship, forwarded to the deputy registrar.
This is not a review.
Lordship, in fact, Lordship, it's a review petition. If Lordship takes the order sheet of the deputy commissioner, deputy registrar at page 36, Lordship. 36, Lordship. The second paragraph, Lordship, I'm just reading, Lordship. Therefore, you are directed to attend the hearing with all relevant records on 24/3/2020 at 11:30 AM in the office chamber of the undersigned to review the settlement of the following Bakizai case, which was already settled by the then Bakizai officer and sub-register of the Cooperative Society Guwahati, Jiban Hazarika. There are 3 cases, Lordship.
By the district deputy register of cooperative
Societies.
He has the power to review.
Yes, Lordship, the act says that if a incumbent, Lordship, he goes on a superannuation, that any officer, Lordship, he can be authorized to do the same. Lordship says 54 of the act is there.
No, Mr. Counsel. Review has to be before the same authority.
Lordship, same authority.
Who is the same authority?
Because the Bakizai officer.
The same authority is the respondent number?
3, Lordship.
3. Yes.
My Lordship, may I make one submission? Lordship, this writ petition.
You are going to return the amount?
Lordship, only one submission, Lordship. Lordship, this writ petition is not maintainable for the very ground that, Lordship, the bylaws of the bank authorize the board of directors to institute any cases. Here it has been instituted by the managing director. Managing director does not have the power to institute a case under the bylaws of it.
Let us not go into this trivial issue.
Lordship.
Yes, why the review has not happened?
My lord, the review has been, my lord, may present.
There is an order being passed at page 36. What has happened thereafter?
Lordship, thereafter we have been intimated because an internal inquiry is pending against the Bakizai officer. So review hearing could not take place. Lordship, how can that attack a review, Lordship, jurisdiction? That's why, Lordship, we prefer an appeal before the appellate authority.
Have you prepared an appeal?
Yes, Lordship.
What has happened to?
Lordship, the appellate authority are now saying that they have not received the copy of the appeal. It was duly acknowledged by them, Lordship.
Where?
I have annexed, Lordship, everything. Lordship, page 38, Lordship. 38, Lordship.
Before the deputy commissioner comes, is the appellate authority?
Appellate
The
authority
Bakizai.
for Bakizai.
And this appeal was received.
It was duly received during the COVID period, Lordship.
How do you know? Oh, this sign,
Sign, Lordship,
18th of September.
18 of September.
Then, now they say status of the appeal. What do they say?
No, Lordship, they have not received. Lordship,
And they inform you that your application has not been received by this branch. So they only said by this branch. In pursuance to the managing director is hereby entrusted to inquire into the alleged irregularities in the settlement of so and so. This order has been passed during COVID
yes, Lordship.
without giving an opportunity against him. This is oh. Our COVID started on 18th of March.
March, Lordship.
19th, when everything was closed, he passed this order.
Yes, Lordship.
Goodness.
In fact, since the respondent number 3, Lordship, now have admitted that the order was passed by the Garden Bakizai officer.
Anyway, to resolve the issue is to make it simple. Yes, Mr. Hendik, what to do with this? An appeal has been filed. What are you doing?
Lordship, my lord, in this figure, my lord, we have already filed an affidavit.
What
In
is your
our
stand?
affidavit, my lord, we have stated that the paragraph 4, Lordship. So, my lord, that Lordship may kindly peruse the paragraph 4. Affidavit filed by the respondent number 4, Lordship.
Anyways, so you have not taken any action because of the fact that it was not placed in the right branch. Now, whatever maybe they have filed, you have not taken into account, but now let him file it. And you take an action. And this period shall not be taken into account for the purpose of limitation. I think that is a fair thing. Dispose. 15 days, submit the bid.
26.
My lord, this is regarding 49 million acres of land, which was patta land, but later on it became cash. Because the land was within the river Brahmaputra. So for some years, they did not pay real revenue. And ultimately, without our knowledge, the land was made cash. So we have filed representation that this is not originally
Yes, government, you have not filed affidavit.
they have not yet filed.
Mr. Hendrik, you are not filing affidavit.
Not filing, my lord, that's instruction.
2 weeks time granted to the respondents to file their affidavit.
Alright.
Lord, in this case, my lord, I prefer an adjournment. My senior, my lord, he made an accident and he fractured his leg, his hand, my lord. Maybe take it next week, my lord.
Mr.
VK Borwa, my lord.
VK Burwa, counsel appearing on behalf of the respondent number.
My lord, respondents, my lord, State Bank of India, respondents.
Respondent seeks for an accommodation to submit the matter again on 15th of September.
Highly obliged.
May I please, your lordship? Lordship, the matter here pertains to non-payment of contractual liability, lordship. Lordship, there is an amount of 37,17,279. On the
Which
last date-
department?
Lordship, PHE. Lordship, on the last date, they have produced an instruction regarding the dispersal of 20 lakhs only. Lordship, the rest of the amount is due to the petitioner, lordship.
My lord, as per our instruction, the 20 lakhs, that is the only amount discrepancy in the amount. They have claiming 37 lakhs, but as per our record, they are entitled to 20 lakhs.
And non-availability of the funds, so you could not
Yes, ma'am.
pay within 6 months this 20 lakh.
My lord.
The instant petition has been filed by the petitioner being aggrieved by the inaction of the respondent authority in not making the payment of an amount of 37,17,279 to which the petitioner claims to be entitled. This court had issued notice on 24/8/2022. It reveals from the records that on 29/5/2023, the counsel appearing on behalf of the PHE had submitted that the departmental authorities have found records as regards non-dispersal of an amount of rupees 20 lakhs 31,870. Today, the learned counsel appearing on behalf of the PHE department have produced an instruction issued by the executive engineer PHE a copy of which was also sent to the chief engineer PHE Assam. From the same instructions, it reveals that after departmental verification, it has been found that only an amount of rupees 20,31,817 is payable to the petitioner. However, it is mentioned that on account of non-payment, non-availability of the fund against proper head, payment could not be made in due course. It has been further mentioned that fund demand has been placed by letter number PHEE /G Roman 2 ACCTT 194 2022 23 674 dated 25/5/2022 without budgetary provision. It has been further mentioned in the said instructions that the petitioner had also agreed at the time of execution of the work, receiving the work order, that the payment would be received subject to availability of the fund against proper head of account only. The said instruction is kept on record and marked with the letter X. The learned counsel appearing on behalf of the petitioner, however, submits that the petitioner is entitled to an amount of rupees 37,17,279, and the total amount has not been taken into consideration by the respondent authorities. I've heard the learned counsels for the parties and I have also perused the materials on record, including the instructions. From the above materials on record, more particularly from the document kept on record marked with the letter X, it transpires that the respondents in the PHE department have admitted that the petitioner is entitled to an amount of rupees 20,31,817. However, the said amount had not been paid to the petitioner on account of non-availability of the fund. This court finds it relevant to observe that non-availability of the fund cannot be a reason to deprive the petitioner for long. And denial of such for long. Accordingly, this court directs the respondent authority, that is the commissioner, and what is that? Who is the authority? Directs the the commissioner and secretary to the government of Assam PHE department, as well as the chief engineer PHE water Assam PHE. Accordingly, this court therefore directs the respondent number 1 and 2 to make arrangements seeking necessary budgetary allocations so that the petitioner is paid the amount of rupees 20,31,817 within a period of 6 months from the date a certified copy of the instant order is served upon the respondent number 2. This court further finds it relevant to observe, in view of the submission of the learned counsel for the petitioner, that the petitioner is entitled to 37,17,279. Taking into account that the respondent's authorities have, upon verification, found that only an amount of rupees 20,31,817 is payable to the petitioner, this court cannot adjudicate as to whether the petitioner is entitled to a further amount beyond 20,31,817, as that would be entering into dispute, the arena of disputed questions of facts. Accordingly, this court is not inclined to this court. In that view of the matter, this court is not inclined to pass any directions in respect to the amount beyond 20,31,817. However, liberty is there to the petitioner to approach the court wherein disputed questions of facts can be adjudicated.
Flash copy.
Good.
29.
So in this matter, the pleadings are complete. May I pray that date may be fixed for admission hearing in the.
Madam, Assam Pharmacy Council is which one? Regarding what matter?
Regarding implementation of certain provisions of the Pharmacy Act. Their prayer has been rejected by the government and they are challenging that rejection.
Chalu, we'll have it some other day. When?
Lordship, any day convenient to you.
After vacation?
No, Lordship, next week.
What is the urgency?
After 1 week.
Oh. List the matter on 18th of September. No, we'll have it on 19th. You want a early disposal?
Yes.
Okay. List the matter on 19th of September 2023, on which date an attempt shall be made to dispose of the matter.
Much obliged, Lord. 30.
Yes, Mr. Sheikh.
My lord, your lordship would be pleased to see the report dated
Submit a report in pursuance to the order passed by this court. Yes, what is this report? Who is to submit? Raisi. Oh. Raisi, report.
Flag C may be seen, madam. Flag C.
Yes, with reference to the order dated passed by this court and on receipt of the application for release of the necessary procedure regarding identification, because since the verification of the was not received, on being further verified. So you got the money?
No, my lord, till date, I have not received the money.
No, it has been given.
My lord, it is said that check in favor of Flag C, my lord. Check in favor of Grameen Vikas Bank, by check number so-and-so dated 8/8/2023 to transfer via NEFT oblique RTGS to Nur Jahan and Moinuddin Sheikh. So, my lord, only thing is this one. Let the matter may be listed on some other day, my lord, after 2 weeks like this.
Not necessary, it will go now.
Let me obtain instruction from the party, my lord. Because, my lord, the learned counsel there, my lord, is in bereavement. His mother expired, my lord, so I cannot get the information. In some other day, my lord, if I get the money, there is no cost here.
See?
Cost survive, my lord.
See? After this will happen. Amount has been directed to be disbursed when the matter has been pending unnecessarily.
16, from 16, madam.
See? Matter has been pending unnecessarily.
From 16, my lord, that process was not done.
One
When
order.
your lordship passed this order, my lord.
Everything moved. Okay.
On 4/8/2023, then the process started, my lord. Now, your
On
lordship-
8/8/2023, direction has been given. Anyways, Mr. M.
On some
the
other day,
learned
my
counsel, and I have this court
After
have
15 days, my lord. My lord.
this court had duly don't require. This court had duly taken note of the report submitted on 9/8/2023 by the Registrar General, Guwahati High Court, wherein it has been mentioned that the amount of rupees 1,50,000 was released to the petitioner oblique claimants while NEFT oblique RTGS in the manner stated therein. Mr. M.A. the learned counsel, appearing on behalf of the petitioner, submits that he would like to take instructions from the petitioner as to whether the said amount has been deposited to their accounts. List the matter again on 28/8/2023.
Obligation.
It will be done.
31 and 32.
Kita asit.
May it please the Lord.
Yes.
Lordship, the petitioners prayed for reclassification of their lands, Lordship, in the year 2012, Lordship. And thereafter, their lands were acquired, Your Lordship, and the award was given on the rate of agricultural rate, Lordship. So we prayed before this court, Your Lordship, our reclassification was not done. If reclassification was not done, Lordship, the compensation amount will be not enhanced, Lordship. So in item 31, they have filed affidavit saying that in the year 2012, we have not filed a application, Lordship. But we have filed our reply saying that after issuing notice, immediately we filed our application, Lordship. In the second.
Application for what?
For reclassification, Lordship.
Understood, but have you asked for reference?
No, Lordship, our application was.
Has the award been passed?
Yes, Lordship.
What have you done thereafter?
There we have not challenged that award,
Then,
Lordship.
If the award have not been challenged, if we have not sought for a reference, what remains? Tell me.
Lordship, unless Lordship, our lands were reclassified as non-agricultural land, Lordship. We cannot pray for enhanced rate as because the compensation was awarded on the basis of.
You see, these are matters which has to be proved before the reference court.
No, Lordship, for reclassification, Deputy Commissioner is the competent authority.
No, madam, let us assume that this court passes an order that you reclassify. Can you today make an application seeking reference after the award has been passed? You can't, because there is a period. If you go by the section 16, it was done under the 1894 Act, then it will be 6 weeks if you are present, otherwise 6 months. If it is otherwise, if you are under the 64 Act, the provision, section 12(2) categorically says that the provisions of section 18 and 19 shall apply. Section 64 of the 2013 Act also mandates the same. And what to do now?
First, we have to reclassify our lands to
For
non-agricultural
what?
lands, Lordship.
Now the land belongs to them. They want to reclassify, don't want to reclassify, it is gone, the land has been acquired. But for that, are you not required to file an application seeking reference?
Lordship, for that, whether they have.
Can you
received-
file it now?
Whether they have received the compensation or whether they have filed any application, that is not within my knowledge, Lordship.
So you have to take that information. Otherwise, why should this court make an unnecessary? Because as of now, you are not the owner. Once the award has been passed, once the possession has been taken, the land has already vested upon the government. Well, now that will be, for what did you take the land?
For
Some
multi-
park.
multimodal logistic park.
Logistic.
Power project?
Logistic park.
Park. Now this will be child play
Yes.
park and all. Which has no relevance. Mr. R.S. Chaudhary, the learned counsel appearing on behalf of the petitioner shall obtain instruction as to whether the petitioners have filed reference application before the collector. This is done under what provision?
Lordship, National Highways Act, Lordship.
This is done under National Highways Act.
Yes, Lordship.
So you have to
My-
file it, your, under this act. National Highway.
3G, Lordship.
The National Highways Act, they have taken it for
There's
park.
a,
No,
multiple
no.
logistic park and
You
some
know-
other Lordship purpose also.
No.
Lordship, kindly see page 20 of annexure 4, Lordship. It is hereby informed to the affected parties to below mentioned village understands to give compensation regarding requisition of land for the construction of new national highway, Jogigopal Link Road. So some roads are also, Lordship, there.
Maybe part of the land, because we have said in our
On
evidence.
construction of a new national highway and Jogigopal Ring Road. This is done under what provision?
Thing is,
Compensation is to be paid.
Lordship, is, Taken under national.
No, it can't be, you can't appoint it. It is, this can't be under this act because here the National Highway Act, if it is to be done, it can be done only by the competent authority who has to be appointed by the central government. And this is a state government who has done it. Well,
Lordship, page 22, your lordship will find amount of compensation of land acquisition for development of multi-model logistic park and external connectivity to MMLP at Jogibakupa. So some lands were acquired for lordship road and some lands were acquired for multi-logistic park. Lordship.
acquired the land by LA case number 4/2 for the purpose of development of multi-modal logistic park and external connectivity to so and so.
In Bongaigaon, there is a proposed for port construction. Lordship. And your lordship will find that annexure 1 page 15 in the year 2012 they issued notice.
Who is appearing for a review?
Yes.
Yes, under what provision you have acquired?
That is silent, my lord. The instructions we have received, but it is silent. It is for the purpose is there.
Purpose is okay. I am asking under what provision you have done? And who has done the acquisition? The state or the center?
Silent.
You get the records of LA case number? What's the LA case?
Lordship, LA case number.
I don't understand. What is, why do you don't put the provisions of the act?
Lordship will find page 21, it is written ইয়াৰ দ্বাৰা বৈতামাৰী ৰাজহ চক্ৰৰ অন্তৰ্গত নিম্নোক্ত গাঁৱৰ মাটি অধিগ্ৰহণৰ বাবে ক্ষতিগ্ৰস্ত পট্টাদাৰ সকলক জনোৱা যায় যে নতুন ৰাষ্ট্ৰীয় ঘাইপথ NH 17 আৰু MMLP যোগীঘোপা সংযোগী পথ নিৰ্মাণ কৰাৰ ক্ষেত্ৰত মাটি অধিগ্ৰহণ কৰাৰ বিপৰীতে ক্ষতিপূৰণ আদায় দিয়া হ'ব। So there was a project, Lordship, in connecting that project, some lands were acquired for road construction.
What is the LA case number?
4/2019 and 20, below that, Lordship.
It will be with whom? Mr. Talukdar, you are paying for whom?
I'm appearing for government.
And you?
And for the department, revenue.
Revenue
And
department.
what is that government business?
Government, my lord, the DC, deputy.
This.
My lord, we have filed an affidavit, but it is silent about under what act or acquisition under what act and
Mrs.
for
R.
what
Chaudhary
purpose.
appearing, Miss R. Chaudhary appearing on behalf of the petitioners shall obtain instructions as to whether the petitioners herein have sought for for determination of sought for a reference to the court for determination of the compensation. So, Mr. B.J. Talukdar, the learned counsel, senior counsel shall also
Our entire petition
produce
is
the records in respect of LA case number 4/2019-20. In as much as nothing is clear as to under what provision of law the said land has been acquired. List the matter again on 20 September 2023.
But by this retention, they only seek for reclassification. of the land.
Understood.
Madam,
You are not clear. You don't know.
we said that.
No, first of
application
all,
was
Mr.
after the
Mr.
issuance of-
Talukdar, tell me how on earth you even don't care to mention under what provision you are acquiring.
No, that is.
At least are
I'm-
these
I'm
people not entitled to? This can't be under the National Highways Act because it is done all by the state.
State.
And as such, To do it under the National Highways Act, it is to be done by the central government where a competent authority has to be appointed. Where everything has been done, you don't know under what provision you have done.
Only probably because they are.
Because then the question will be different.
Lordship, I understand.
Why I'm saying, if it is done under the National Highways Act,
Then-
thereby appointment of a competent authority will be there. Then their right to be move the application for reference would be different.
Entirely different.
And then they will be asking for an arbitrator.
Probably because, my lord, the entire writ petition, the pair in the entire writ petition is for reclassification. of the-
Understood. But you see, once you have taken the land, does it make sense for a reclassification
No,
unless
No.
they want to get a higher compensation?
I-
Now,
I-
to seek a higher compensation, they are required to apply somewhere. This court can't give them a higher compensation. So why should this court at all go for
getting that
reclassification?
higher compensation, they want to reclassify the land. That cannot be done because prior to their application, the notice under section 4 was issued.
For which?
For the acquisition of that.
Under what provision?
As
So it is therefore, if it is 4, that means 64 is out.
Well.
No, you have not done the section. Are you saying that you have exercised 4 in respect of an LA case which is of 19 and 20 when from 1/1/2014 the new act has come in? We set aside the
I'll take
acquisition.
that,
Then
I'll take the record.
Then-
I'll take that.
that is why I'm saying
33.
And it is not a case that lordship after acquisition we applied. A lordship in the year 2012 we applied.
understood, madam, but the things are not clear. That is why I've asked them.
33.
Applied. 32 same lordship, different.
Okay. Release the matter after 4 weeks.
34.
Release the matter after 3 weeks. In the meantime, you have filed affidavit.
I will file. I will file those.
In the meantime, the FPDCL shall file the affidavit.
35.
Yes.
Not matter pertains to lordship disqualification of directors not under the Companies Act of it. And we are addressed by the my lord holding of my lord DST and DI and this dismissal certificate and director's identification number. This lordship, we would like to file an application for amendment of our REIT application form.
Huh?
We would like to file an application for amendment of the REIT application form.
Why?
Also because we have to challenge the proviso to section 167 of the Companies Act, which enlarges the scope of my lord the vacancy of directorship in other company. That was not there, my lord, in the REIT application.
So you want to amend it.
Lot. Amend the REIT application.
Now you want to challenge a provision of law.
Lot. That is proviso to section 167. That was newly added to the statute lordship on my lord on with effect from 3/1/2018.
After filing of the petition.
No, my lord. It was prior to that lordship.
Then why didn't you challenge it earlier?
My lord, there are two sets of writ petition lordship. Some writ petition pertains to the period earlier to 3/1/2018, and some writ petition pertains to after the amendment has been brought. Somehow it was not challenged.
It's the matter after 4 weeks.
Deeply applied.
54 and 55.
Yes, madam.
Lordship may not like to take up. Lordship may not like to take up this matter.
Why?
Dr. Saraf is appearing.
Oh, okay. Release the matter before any other bench.
56.
Mutat किया है? हैं? Yes, Mita Gupta.
He has not come. He has not come, Mr. Gupta. Responded.
Oh, Mr. Dhiman. Why the matter is before me? Before appropriate bench.
Once it has already come before Lordship. Earlier come.
Hello, when do you want?
21st Lordship.
August.
Lordship.
When?
At 21st or 22nd.
Your matter is that, no? Can, after the award has been passed, now, what can this court do?
Lordship, something is wrong on that day because I came from Chandigarh. Some misunderstanding was there. The order date is Lordship 2/23, earlier order of different bench. The matter was like that after termination of mandate, the London District Judge has extended a time to the arbitrator when no party has applied to that. That was the basic order. And when they have no power to extend the date, then arbitrator cannot publish the award, Lordship. Or there are certain other things which I want to explain. If
Understood very well, but couldn't that come on the 34?
No,
34, the period is over.
Lordship, it is not like that. The power given by the district judge, extended by the district judge to the arbitrator, the district judge cannot extend, Lordship. Supreme Court already NPCC versus University has said that once a 12-month time is expired, after that, we both the party extended the time for 6 months. And the law says after that, we cannot extend the time. But in that time also, arbitrator has failed to publish the award. Then I come before the lower court, court below under section 14 for termination of the arbitration. Or Lordship, nobody has filed any objection over there for 2.5 years. The other party. Then what happened? The learned district judge on their application, they extended time for 1 year. The learned district judge has no power to extend until otherwise the application filed by either of the party. This is what a
On whose application the learned is?
The respondent Union of India, they have not filed an application before the lower court by extend our time for arbitrator. Neither I have filed. Then ultimately,
Then who extended it?
the learned district judge.
In whose application? On its own?
On its own. And giving a award after
No,
that.
I hope you have challenged the this also, no? The award you have challenged.
Oh, not sir. That is not award has not been opened. It is lying there because nobody has deposited the money of award.
Please set aside the order dated and review order dated may kindly be terminated. May kindly be terminated mandate.
Lordship, one people.
Oh, so he has not given because of his retaining lien.
Lordship, one thing drastically has been done before.
Okay, we do one thing on 22nd.
Lordship, kindly that day, please, Lordship.
We are here for a few days.
I'm here. I'm going Calcutta. I'm coming back. That's Lord.
Then we'll do it on 24th. 22nd, there are a lot of matters.
Lordship,
some other councils from outside is
that
coming.
day, kindly be listed in this bench only. Otherwise, sometime it goes to other one.
No, it don't go.
No, please, Lord.
This matter has come before me after that also.
Please, Lord, it may be.
Okay. Matter having been heard substantially, let the matter be listed again on 24th August 2023 for final disposal.
Obliged, Lord.
Number 37 for orders.
Yes, orders, sir. Order none has appeared on behalf of the imperial. It appears from the order of the Lozima Court dated 24/1/2020 that the petitioner had not taken steps for issuance of notice to the respondent number 4 Full stop. List the matter. No, this court grants 3 weeks time, 2 weeks time, 3 weeks time to the petitioner to take steps upon the respondent number 4.
Well then, Lordship,
Feeling which the matter be listed again.
respondent number 1, Lordship, may kindly see that State of Assam represented by Commissioner and Secretary to the Governor of Assam, which department, which this is not mentioned in the matter that time.
Okay. We this 38 killing last time too. Failure to do so. The matter be again listed before this court. Next.
38.
Yes, you have not taken steps. Respond number 10.
All the steps taken from 25th, 4th, 19th, 18th.
You have not taken steps as regards respond number 10.
I'll take,
Huh?
I'll take this.
Is the and the learned counsel for the petitioner submits that he will take steps upon the respondent number 10 by way of registered as well as usual within 10 days.
Yes.
List the matter after list the matter after completion of service upon the respondent number 10. It is made clear that if no steps is taken, the matter be again listed before this court.
39 to 44.
Yes, what is it?
Lordship, steps has been taken. Steps has been taken, Lordship.
Taken?
For service.
No steps have been received. The learned counsel appearing on behalf of the petitioner submits that the steps have been taken when?
Before 7th August. Before 7th August.
On 7th of August? 7th of August 2023. The respondents, the registry shall verify the same and list the matter before this court if such steps are not taken.
46.
Okay, sir.
Right, please, your lordship.
Yes, you are for it.
ASIDC, man.
Oh, SIDC. There's some amount to be paid additionally,
my lord,
they are saying.
The thing is that, my lord, the order, my lord, which they have reviewed is, my lord, the order, my lord, directing the managing director to pay the amount. But, my lord, even if that order is challenged, my lord, the order, my lord, fixing the amount, that is ordered at 21-2, my lord, has not been challenged, my lord. So that finding will stay, my lord.
They are saying, you see, at that point of time,
My lord.
the earlier order when it was passed,
Yes.
they have not, there was a mistake on the part of the council to give the figures. On the basis of that, this court passed the order with the wrong calculation.
Yes, but
When the matter came up, when the AICDC managing director was there, he said they okay.
Yes.
Then on that day, Mr. Sheikh was not there, but there was some affidavit, some file which this court had not taken into consideration. Only question is something around 15,000, 12,000 something.
My lord, 955,000.
Total
Total.
addition you have to get.
Yes, ma'am.
Everybody.
No, my lord. Total. Supposing, my lord, one petitioner 15, another petitioner, my lord, 1,45,000. Another is 2,20,500. Another 3,47,000. Another 2,27,000.
What is your basis to say that these amounts are there?
My lord, I have given the chart, my lord. Total amount was 6,15,000. I have received 6 lakhs. Another amount, my lord, 2,91,000, I have received 1,45,500. So that the balance amount is 45,000, my lord, 45,400 in this way.
You make a verification,
Okay, ma'am.
not to go as per this, the instant review applications. The 5 review application, all these are yours, no? 5. The 5 are yours?
Yes, ma'am.
The above 5 review, the instant 5 review applications have been filed, challenging the order dated,
3/3/2023.
seeking review of the order dated
3rd March. 3/3/23.
3rd of March 2023. On the ground that there was a mistake on the part of the council on the earlier occasion, that is on
28th, my lord.
21/2/2023 in giving the entitlements of the petitioner. However, later on, it was realized that the amount which the petitioner is entitled to is more than the amount as stated in, as was submitted on 21/2/2023. And as such, have sought for review of the order dated so and so, a review order to date to 3/3, na?
3/3/2020.
The learned counsel appearing on behalf of the AIDC, ASIDC, shall obtain instructions from the ASIDC as to whether the petitioners herein are entitled to any further amounts apart from the amount which have been already given. An affidavit in that regard be filed by 7th of September. List the matter again on 13th of September.
Obliged. Highly obliged.
47.
Very good. Now. Matter